requirement to get to heaven? Perfection. But ain't nobody perfect. Jesus died so we can get to heaven. Cause he thought we was worth it. So check it, B, they hung him high, stretched him wide. Then he hung his head low. Yeah, then he died, but he's alive. And he got me on the go. The devil at me, y'all. He thinking I'ma fall off. I'm on the job, no off days, no call-offs. And I don't need a gangster grill like Paul Wall. Christ driving, I got shotgun, a sawed off. So I'm paused off, and he's driving me, provides for me. I'm the master's like a high degree. Stuck to him like a twin. Siamese, this ain't talk. I got evidence like a crime scene. Like how I used to walk around blind. He gave me clear eyes when I dropped no Visine. Gave life to a pipe dream. Cause I was bamboozled since them school days. That's Spike Lee.
Yeah, yeah. We are real strong people. Yeah, yeah. We can do anything. Yeah, yeah. We can't be worried about what they say. My brother, my sister, just believe in yourself. Believe in your skin, believe in your health, believe in yourself. Believe in your talk, believe in your walk, believe in yourself. Believe in your skin, believe in your health, believe in yourself. Believe in your talk, believe in your walk, believe in yourself.
Since everything starts with self, let me hold this mirror up and take a look at myself. Before I judge you, I gotta check myself. And I come to find out that that's good for my health, right? Change your mind and watch the whole body follow. So you won't hear me talking about I'm hitting you with hollows. I can't do it, got plans for tomorrow. And I ain't trying to bring my seeds no type of sorrow. Wait, cause fake rappers do fake-ish. I mean, most the basic get replaced quick. I'll never sacrifice my soul. Truth is, so I might never get 1 million records sold. But that's cool, cause I'm good with the creator. He nurtured my thoughts, so I present you with verbal flavor. You never listen to what no haters say. We pray for them, but we gon' move it this way. We moving forward, y'all.
Yeah, yeah. We can do anything. Yeah, yeah. We can't be worried about what they say. My brother, my sister, just believe in yourself. Believe in your skin. Believe in your health. Believe in yourself. Believe in your talk. Believe in your walk. Believe in yourself. Believe in your skin. Believe in your health. Believe in yourself. Believe in your talk. Believe in your walk. Believe in yourself.
I feel like George Floyd, yo, I can't breathe. It's hard to conceive on why they wanna kill we. I think they wanna break our spirit. The youth won't hear it. We die over loose. These cops scared to quit it. I send my love to Eric Gardner's family, cause them pigs went and took away somebody's daddy. Sands with Bland, Trayvon Martin, Ahmaud Arbery. The world sees what's happening. Yeah, so in the midst of our hardest pain, we believe in ourselves and face our darkest days. You know, they be mad when we come together. So after the protest, stick together. Take the pledge, I will fight but won't kill a brother. Cause I can't take your life if you are my brother. So I'ma send you love, not one shell casing. Believe in yourself and change our situation. Yeah.
Believe in your skin. Believe in your health. Believe in yourself. Believe in your talk. Believe in your walk. Believe in yourself. Believe in your skin. Believe in your health. Believe in yourself. Believe in your talk. Believe in your walk. Believe in yourself.
Here we go, y'all. We are back in the building. Good to see everybody in here. Y'all get ready. Oh my gosh. This is going to be one of the craziest live streams that we have done. I hope y'all are ready, man. Y'all know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. Look, we looking all crispy and clean on the screen. Ooh, I need to fix my, hold on a second, y'all. I need to fix this backdrop. I don't like how that's looking. I have to fix my background for a second. We got to be professional up in here. There we go. We're back in the building, man. This is going to be fun. This is going to be one of my favorite live streams of all time. Hopefully y'all are ready. Welcome back to another YouTube live stream and another episode of the Music Morning Show. I'm your host, ClassE Beats at ClassEbeats.com. Today, we're going to go, man, we have so much to go over. I'm not going to waste any time. We're going to go ahead and get into it here in a second. We've got some verification of some of the things we've been saying, y'all. The state is watching. They are watching these live streams that we're doing. They're watching everybody who's talking on YouTube about this YSL trial. And we've got proof. They provided the proof. They told us they're watching this and they see everything that's going on. Also, we got another I told you so moment when it comes to talking about all these attorneys and these sworn witnesses that have been out on YouTube talking about this trial. Y'all remember, I doubled down, even though there was so much pushback from people saying, oh, just let them get their money. Oh, it's okay. It's fine. No, something that didn't sit right. Something didn't sit right. So we're going to go ahead and get into it. We've also got some other motions filed. The state responded to some of the motions that were filed by Brian Steele, the lawyer of the year, and Young Thug. I'm hyped. I'm so excited for this live stream. Y'all are going to enjoy. Do me one favor, though. If you're here, make sure you like the video on your way in. Make sure y'all show some love. Likes are free. And not only are they free, but it helps the channel to grow. And it lets the algorithm know you guys are enjoying this show. All right, let's go ahead and get into it. I got to say what's up to everybody who's in the chat first, though. Let me see who we got up in here. We've got Mr. Tesla's in the building. You know what it is. He said, y'all drop a like on the way in for sure. El Papicito is up in here. We've got Brenda Berryman is in the building as well. Says, is there court in the AM? There is not. We are not continuing the court proceedings until the 30th, which is going to be next Tuesday. But do not worry, Brenda. We've got a lot of information for you today that I think you're going to really enjoy and find interesting. Also, we've got Lauren Robinson is in the building. We've got the amazing Amy Lee is up in here in the chat. Shout out to Amy Lee. Always appreciate seeing her here. We've got Kristen Vasquez is in the building. Who else is up in here? Mixed Chick Samantha's in here as well. Shout out to her. Good morning. Good morning. We've got Elu says, Illuminati. That one gets me every time, man. That is one of the greatest usernames I have ever seen. Illuminati is up in here. Says, ClassE, what's good? What's good? I'm so excited, y'all. This is going to be a great live stream. Lauren Robinson said TLA was on last night. It was wild. Yep, I watched every second of it. I learned so much from TLA and AV, and we got to give them a big shout out. A lot of the times, even in preparing for this live streams, I will go and I will make sure I watch and tap in with the lead attorney specifically and AV as well. And there's a lot of other great content creators on YouTube, but especially the professionals, the people who are in it like AV and TLA, because they just give so much more background and insight from not only being on the legal side, but just from perspective from the hundreds of hours of experience they have in law. So we got to give it up to TLA and AV to the 7th power. Y'all, please go make sure you check them out and show them some love. All right, who else we got in here? Roro's back in the building. What's up, Roro? Good to see you. We're going to get into it, y'all. I have one announcement I want to get into, and then we are going to go ahead and get ready with the show. All right, y'all know what time it is. It is Wednesday, which means tonight, 8 p.m. Eastern Standard Time, we've got another episode of the Song of the Night Live. This is a special episode because it's a versus challenge featuring 4 amazing artists who are going to compete to claim that next spot in the season 9 tournament. So if you're an artist, or if you're just someone who enjoys hearing music from new up and coming artists, make sure you tune into the show. All the artists, you'll get a chance to win $100 and a brand new Shure 55SH microphone. All right. Also, we had some issues during the last stream, which was on Monday, And so we're going to be picking the winners from that show at the beginning of the show as well. So we got a lot going on tonight, a lot going on with this live stream. It's going to be fun, y'all. It's going to be a fun time. I'm excited to be back with y'all in here today. All right, Hollywood Co is in the building. What's up, man? And thank you to everybody who's liked the video so far. We got a lot of y'all in here. And shout out to Illuminati, says greatly appreciated, love the show. Thank you, thank you, thank you. Yeah, see, yesterday was the first show that we had missed in a while. And shout out to Colleen Harrison is up in here. Thank you for stopping by, Colleen. All right, if y'all are ready, we are going to go ahead and get into it. All right, let me get a couple more comments and we'll keep it going. And Amy says, look at all this love and appreciation in here. Appreciate y'all. Yeah, that's dope, man. That is dope. Let's go ahead and get into this first one. Oh man, y'all, this is going to be so crazy. So crazy. That is the wrong one. Oh, I forgot. You know what? I completely forgot to say, if y'all want to call into the show, the link to call in is in the description. We have, let me see, 1, 2, 3, 4, 5, 6, 7, 8, 9 motions that we have to get to through today. Now, most of them are pretty short, so y'all don't feel overwhelmed and be like, yeah, we're gonna be here for 3 hours. Most of them are pretty short, but we're definitely gonna have some conversation about some of the things that are mentioned within these motions. This first motion is the longest one. It's about 15 pages. We probably won't go through every single one, but there's a lot of good information here. If y'all have thoughts on any motion or any notice that we cover here, you can call into the show. The link to call in is in the description as well as in the pinned comment in the chat over there. All right, let's see. We got a couple more comments and I just love hearing y'all's comments too. Roro says, yes, AV halfway lead attorney is great too. Yep, shout out to them. Lauren Robinson says Brian Steele, seriously a goat. He's killing it. El Papicito says, on a side note, something shady is going on with Bumpus and Woody. Both their channels have been scrubbed clean. Yeah, we talked about that, El Papicito, and y'all are really going to enjoy this last motion that we're going to look at. I'll give you a sneak preview. This the state's motion to restrict extrajudicial statements. This is very important right here, and we're going to talk about why. Because if you look down and you go to some of these exhibits, you see the state pointing to specific YouTube videos and interviews that were done here on YouTube. So again, I mentioned this to y'all. One of the biggest reasons I wanted to stay away from anyone who is actively involved in this case is because of this right here. But we'll get into that later. We've been talking about it for several weeks, and I love saying I told you so. But there's a reason. There's a big reason. Amy Lee says they are scrubbing it themselves. They want to fool me. You know what's up. Colleen Harrison is in here. He said, hello, enjoy your content on this YSL trial. Aww. Thank you, Colleen. I appreciate it. Yeah, the state's in here. They're in here watching today. Don't worry, y'all. I'm not going to be called as a witness. I'm staying away from this case. We're just commenting on it, and all this information is publicly available. So y'all leave me alone. I'm not trying to. Shout out to Fulton County, but no, we ain't doing that. Variant said, Weinstein said the state can't silence him, and he's doing an interview today. We're going to get into it. All right, let's go ahead and get this first one out the way. Again, if y'all could, we are at our 50% likes to views ratio, but if you could, everybody like the video. Again, it's free and it does help the channel continue to grow. All right. So we have tons of motions in this YSL trial that got filed yesterday, and we even have the state responding. The first one that we saw come down is from our guy, DeMonte Kendrick, aka Yak Gotti, aka Mr. Doug Weinstein. They put this together asking for a mistrial, and we're going to read and get into some of the details why they're asking for the mistrial, and some of the things that have been going on with the case that we're well aware of. All right, so let's go ahead and get into it. Demonte Kendrick's motion for mistrial. Here we go. Comes now. Demonte Kendrick, aka Yak Gotti, by and through his undersigned counsels, we know that is Mr. Doug Weinstein, and brings this motion for mistrial, shows as follows. We think that this case of this nature, we think that in all cases of this nature, the law has invested courts of justice with the authority to discharge a jury from giving any verdict whenever, in their opinion, taking all the circumstances into consideration, there is a manifest necessity for the act or the ends of public justice would otherwise be defeated. Yeah, they're saying that we need to get the jury out of here. They've seen too much, to summarize that, right? They are to exercise a sound discretion on the subject, and it is impossible to define all the circumstances which would render it proper to interfere. But after all, they have the right to order the discharge and the security which the public have for the faithful, sound, and oh boy, I'm not even going to try. I'm going to leave that one alone. Concedious. Okay, I think I got it. Concedious exercise of this discretion rests in this, as in other cases, upon the responsibility of the judges under their oaths of office. Okay, thank you for that well put and well quoted statement there. The state has had witness after witness fail to prove the testimony that it would like the jury to hear. Right out the gate, he's not wrong. Shout out to Lil Woody. Rarely in the recent history of Fulton County Superior Court has one party had to impeach so many of its witnesses, including at least the following key witnesses: Trontavia Stevens, Walter Murphy, Archillian Bennett, Eduardo Nava Flores. We've got Adrian Bean. We've got D'Angelo White, and critically, Mr. Ex parte himself, Lil Woody, aka Kenneth Copeland. What is the state to do? Losing its case, apparently unconcerned about the need for public justice. God dang. What is the state to do? Basically, with all this being said, how are they going to fix it? They're clearly losing its case and apparently unconcerned about the need for public justice. The state clearly sought an opportunity to restart the trial by triggering an event in such egregious violation of the constitutional right of Kendrick that he would have no choice but to request a mistrial. Oh my gosh. Now goaded by the state and the actions of Judge Glanville, Kendrick has no option but to move this court for a mistrial to respect the constitutional rights of Kendrick and defeat the ends of public justice. While this trial has been riddled with scores of errors, at least 3 deemed an immediate mistrial. And he's right, y'all. We've seen just from the ex parte meeting, Judge Glanville getting legal advice, them pressuring Lil Woody and meeting with him without his attorney. I mean, we could go down the list. I mean, they lied to Lil Woody in chambers. That's 3 right there. And we're not even getting to the rest of the case. Good Lord. While this trial has been riddled with scores of errors, at least 3 demand an immediate mistrial. First one. Oh, so he's going to list them out for us. Shout out to Mr. Weinstein, man. The Honorable Doug Weinstein. First, placed in an impossible position by the state, this court is faced with the task and requirement to reset this case to at least the afternoon of June 12th, 2024. Interesting. I mean, why would they say June 12th? You would think they would say June 10th because that's when the ex parte meeting took place. But I guess the jury wasn't back in until June 12th, or there wasn't any rulings till then. Is the only reason I could think of. Anyway, he said when Kendrick moved Chief Judge Glanville to recuse himself and improperly failed to halt all proceedings pending determination of recusal. Okay, well, I should have kept reading instead of talking. So basically he's saying on June 12th, that is when Doug Weinstein filed the motion for Judge Glanville to recuse himself. At that point, everything should have stopped and they shouldn't have moved forward until they handled the issue of Judge Glanville recusing himself. But that's not what happened. Since that date, the jury heard days of testimony from Lil Woody testimony that can't be unheard. Whew. Yeah, this is bad. This is bad, bad, bad. Second, Yak Gotti's constitutional rights were violated when neither he nor his attorneys were present at a critical stage of proceedings, the secret ex parte meeting among the state, Chief Judge Glanville, Lil Woody, state investigators, court staff, and deputies. Yep, we know about that. Third, Kendrick's due process rights were violated when Chief Judge Glanville wrongly coerced Lil Woody to testify. Ooh. Yeah, that was a pretty scary situation for Lil Woody, man. Just getting out of jail for the weekend, and then you're brought to the judge's chambers with, thankfully, he knew Kayla, but your lawyer's not there. You don't know what's going on. You haven't been able to be in contact with anyone the whole time. The defense isn't there. It's not right. None of the above three reasons for mistrial would exist absent the state's intention to goad Kendrick into the unfortunate position of having to regretfully request a mistrial. Nah, he ain't. I'm not buying that one. You know he wants a mistrial. I mean, unless they think they can absolutely win. But the state handed them a win on this one. All right, so we've got a little bit of the background. We know the background we just talked about. They had an ex parte meeting on June 10th, all right? And then Friday, Lil Woody was coerced into giving his testimony. And then we'll keep going through this. Unknown to any member of the defense counsel, the ex parte meeting proceeding was held in Chief Judge Glanville's chambers on this date, and that was June 10th. We just talked about that. Several defense counsel were later made aware of the ex parte proceedings with sworn witness Lil Woody, though not from Chief Judge Glanville nor the DA's office. Shout out to Kayla. Critically, Brady material was disclosed in the ex parte proceeding and withheld from all defense counsel. And Glanville said, I'm not telling you anything, Brian Steele, until you tell me who told you about the meeting. You messed up, Glanville, and you're out of here. Glanville will probably be in the chat at some point. Shout out to him. Following the secret ex parte proceedings on June 10th, 2024, petitioner filed and presented a motion to recuse and accompanying affidavit from Douglas Weinstein to Chief Judge Glanville on June 12, 2024. I'm surprised they didn't put timely in there, a timely motion. The motion to recuse was based on the impermissible secrecy of the ex parte proceedings and violations of the judicial code of conduct that occurred during the secret ex parte proceedings. The motion was summarily denied instanter. That means instantly, I found out, with a formal order issued on June 14, 2024. So basically, again, Glanville said, nope, I'm not even looking at this. I'm not even giving you an opportunity to argue it. And then we saw Brian Steele did his thing. He went to the Supreme Court, and the Supreme Court said, hey, Glanville, you're done. We're going to send this to Ingram. Ingram was like, what? I'm not dealing with this. I'm gone. Ingram gets out of there. Then they said, okay, Judge Rachel Krause, come on in. It's your turn. And we all know what happened from there. We'll talk about it here in a second. All right. On July 1st, Chief Judge Glanville reversed his order of June 14th, saying that he wasn't going to recuse himself, and referred Kendrick's motion to recuse to another judge to determine the merits of Kendrick's recusal motion. On July 15th, Judge Krause recused Chief Judge Glanville. Got him up out of there. But she wasn't happy about it either, though. When we read that in her motion, it was pretty sad. She said Glanville was doing a good job, but you know, I got to take him out of there because y'all are looking at this and are going to think less of the Fulton County judicial system, which, I mean, it is what it is. Mistrial is required as all proceedings after June 12th are void. This part is where it gets interesting. The honorable court is now faced with an these words, man. Unviable and impossible task of rewinding this case to the afternoon of June 12th. If a party files a motion to recuse a trial judge and the motion is denied, but it is later determined that the judge should have been disqualified to act in the case, all proceedings after that filing of the motion to recuse are invalid and no effect. Unenviable. Thank you. Unenviable. We got it. Kendrick moved Chief Judge Glanville to recuse during the afternoon of June 12, 2024, and he denied that motion. Critically, Judge Glanville failed to follow USCR 25.3 by not halting proceedings and sending the recusal motion to another judge to rule on the recusal. How can Judge... This is one of the biggest things that bothers me. And I get she's covering herself because it's her coworker. How can Judge Rachel Krause say that I think Judge Glanville would have done a great job continuing to rule on this case fairly when it's clearly pointed out in 25.3, and I think we read 25.1 at one point as well, that Judge Glanville should have stopped the proceedings. Like this is how things are supposed to go. But instead, he's just said, no, we're not going to do it. And we're going to keep moving forward. But she says he was doing a great job. What? Come on, man. I was disappointed in Judge Krause. Honestly, I would have liked it better if she had just let this go on to a higher court and say, no, I'm not going to do anything with it. Let's let the Supreme Court decide. To me, I think it would have been better in her case. It would have looked like she was trying to protect Glanville and then she got out of it. And then we would have, who knows what would have happened after that. But yeah, shame on Judge Krause. That's crazy. Subsequently, Judge Krause on July 15, 2024 found that Chief Judge Glanville should have been disqualified. Therefore, under props, don't know what that means. I have to look that up. All proceedings since the afternoon of June 12th, 2024 are invalid and have no effect. So they're trying to erase everything from June 12th moving on, which we kind of talked about, right? The Honorable Court is now saddled with with the repercussions of Chief Judge Glanville's failure to follow Rule 25. He should have halted all proceedings as required under Rule 25 and referred Kendrick's motion to recuse for assignment to another judge. Nevertheless, he persisted. Under repeated objections from Kendrick and other counsel, the tainted testimony of Copeland was presented to the jury over the course of 4 days. The remainder of the day on June 12th and June 13th, June 14th, and June 17th. During that time, Chief Judge Glanville, who had been disqualified, repeatedly ruled against Kendrick and other defendants on multiple objections regarding the questioning of Copeland. And we know Brian Steele, of course, had his motion to recuse in there as well. And he called for a mistrial. Now, this court is tasked with unringing the bell. That's a great statement there, because you can't do that. It's impossible. The jury already heard and saw what was going on because we know they're watching on YouTube, right? How is this court to accomplish this impossible task? How does this court take the jurors' notes from these days? Wow. How does this court take the jurors' notes from these days from the jurors? Whoa, that's quite a sentence there. How can the jury unhear days and days of testimony? They can't. This is not a matter of a witness uttering a single statement that a court instructs the jury to disregard. It is neither feasible nor plausible that an instruction to disregard days of testimony can be followed. Yeah, and I think, they mention it here. Instructing someone to not picture flying elephants only results in the listener conjuring images of Dumbo. Oh man. Shout out to Doug Weinstein. That was a nice touch there. A little cherry on top of this amazing motion. Yeah, and he's exactly right. Y'all know, somebody tells you not to look at something or don't think about it, you're going to think about it. It is what it is. And they have notes. They wrote it down. So they heard it. They saw it. They wrote it down. I mean, y'all know, if you're a college student, those are the three things that you need to hear to actually remember something and make it stick into your brain. So, hey, it's in there. Given the impossibility of erasing the proceedings since June 12th, proceedings that are void due to the state knowingly, improperly requesting Chief Judge Glanville to hold an improper ex parte meeting with the sworn witness, and Chief Judge Glanville subsequently failing to halt proceedings as required by 25.3, the Honorable Court has no alternative but to declare a mistrial. This motion for mistrial would not exist absent the state requesting the improper ex parte proceedings. Simply put, Kendrick was goaded into requesting this mistrial through the state's intentional effort to put Kendrick into this position. So true. Man, this trial is required as June 12, 2024 secret ex parte meeting was at a critical stage and violated Kendrick's rights, right? And thank you to everybody in the chat. I'm going to shout y'all out in a minute. I just want to keep this moving and make sure we get through this because we got a lot of other motions to get through. But Kendrick's constitutional rights were violated when neither he nor his attorneys were present at a critical stage of the proceedings. I wonder if every defendant is going to file one of these. That would be crazy. That would be crazy. Because we already know Brian Steele's doing his thing. He's going to get one up there. Man, the secret ex parte meeting among the state, Chief Judge Glanville, Lil Woody, state investigators, court staff, and deputies. We already know that. Defendants were not provided notice of hearing. Okay, we're kind of keeping with the same theme here. Here, the outcome of the case is substantially affected by the bullying of Copeland into changing his mind regarding testifying. And y'all saw in the transcripts, if you haven't seen the full breakdown of the transcripts, make sure you go and rewatch some of the videos and the live stream that we did, breaking the whole transcript down. You can see this is 1000% too. ADA love, not so much, but Judge Glanville and Simone Hilton, they were definitely making Lil Woody feel like he had no choice but to testify. And they threatened him by saying, hey, if you don't testify, it's Judge Glanville saying this, if you don't testify, I might keep you in there until all the witnesses are heard. And we got a lot of them. So you're going to be here for a minute. Shh. Copeland is the key witness to the state's allegation that Kendrick was involved in the murder of Donovan Thomas, aka Big Nut.
Hey, yo.
While the case against Kendrick is weak at best, even with the testimony of Lil Woody, without Lil Woody, the state has virtually nothing attached to Kendrick to the murder of Big Nut, which is true. The ex parte meeting with Copeland was thus a critical stage of the trial in which Kendrick has a right to participate. Very well said, man. And I love how specifically Doug Weinstein puts these together because they're very easy to read, very easy to understand and comprehend. And I don't know, maybe some of the interviews and seeing that he's been on social media a lot has changed some of the way he's wording these things, knowing they're going to be read by the public. If that's the case, we got to give that man a round of applause. Thank you. Now, Mr. Weinstein, there's still some words that I'm struggling with, but I'll take responsibility for that. You did your thing on this one. A mistrial should be ordered by this court, given that Chief Judge Glanville denied Kendrick's constitutional right to present at a critical stage of the trial, the ex parte meeting with Lil Woody. Furthermore, the mistrial is a direct result of the state putting into motion the ex parte meeting, knowing that such a meeting would goad Yak Gotti into moving for mistrial. Mistrial is required as Chief Judge Glanville tainted the proceedings by improperly coercing Lil Woody to testify. We just talked about this. Copeland's testimony is tainted by improper meeting prompted by the state, where Chief Judge Glanville wrongly coerced Lil Woody to testify. Chief Judge Glanville's coercion of testimony by sworn witness Lil Woody in the face of Copeland's repeated refusal to testify and Lil Woody's statements that he would lie on the stand was an act of impermissible intimidation and a violation of the judicial code of conduct. I think this is great, and I get that they're saying this because this is a key witness and they'd rather get him out of there. But man, I really want to hear the cross-examination of this so bad, because y'all remember one of the biggest statements that was made, especially by Lil Woody in this ex parte meeting, is, I did these crimes. And even if you look at the transcript, that was completely glossed over by ADA Hilton. She heard that and she said, anyway, Judge, we need to make sure, what are we going to do? Are we going to get him some clothes, or are we going to keep moving forward? She was not having that. Lil Woody said in a transcript, I did these crimes. The defense wasn't even there to address that. Excuse me, sir, you did what now? Hold on. What? Crazy. So I would love to see how a cross-examination would go, but looking at this and seeing all the motions that have come down so far, we're probably not even going to get there. If I had to put my money on it, I would imagine that we're not getting even close to hearing Lil Woody testify again. Kendrick's constitutional rights to due process and a fair trial have been violated by the above actions and the state actions in working with Chief Judge Glanville over the coercion has intentionally goaded Kendrick into the only possible outcome. This motion for mistrial that should be granted by this court. As a natural result of the state's action, Chief Judge Glanville has violated multiple rules of the Judicial Code of Conduct, the violation of which denied Yak Gotti's constitutional right to due process and a fair trial. I agree. As requested by the state, Chief Judge Glanville held an improper ex parte proceeding conducted with sworn witness Lil Woody. The secret, I forgot about him being the sworn witness too. Jesus. The secret ex parte proceeding was with sworn witness Lil Woody was also a violation of at least section 2.9 of the Georgia Code of Judicial Conduct, which assures every person of a fair hearing. Yeah, and I want to see this too. So y'all bear with me because I want to read through this and just see what it says. Georgia Code of Judicial Conduct 2.9, assuring fair hearings and averting ex parte communication provides. A judge shall accord to every person who has a legal interest in proceedings or the person's lawyer the right to be heard according to the law. Again, here, don't y'all think Young Thug has an interest? Don't you think Yak Gotti has an interest in what's being said in this ex parte meeting? Come on, man. Judge shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matter, subject to the following exceptions. We're not even going to read the exceptions. Do we need to read the exceptions? What? This section A alone tells you everything about this ex parte meeting was wrong. And again, shame on Judge Rachel Krause for saying that Judge Glanville did everything right. This just, if her job and her position and her goal, as she said, by recusing Judge Glanville was to make the public opinion about the judicial system improve, she failed miserably. And Yak Gotti and Doug Weinstein are pointing that out here. Judges shall accord to every person who has a legal interest in any proceeding or the person's lawyer the right to be heard according to the law. Judge Glanville shouldn't have initiated, he shouldn't have permitted, or he shouldn't have even considered ex parte communications or considered other communications made to them outside the presence of Young Thug, Yak Gotti, Brian Steele, Doug Weinstein concerning the YSL trial or Lil Woody's contempt, which is an impending matter. Unless what? Unless there's a circumstance that requires a scheduling. Nope. Unless the judge believes that no party will gain control from being in that meeting or an advantage. Nope. The judge makes provision to promptly notify all other parties of the ex parte communication. They heard it from Kayla. Disgusting, man. Ex parte communications are presumed to have been in error, likely prompted by the state. Not only did Chief Judge Glanville fail to notify defense Ooh, are they taking shots at Fannie Willis? Likely prompted by the state. I didn't miss that, Doug Weinstein. I caught that. Is he talking about Love and Hilton, or is he talking about the lady upstairs, Fannie Willis? Ooh, likely prompted by the state. Not only did Chief Judge Glanville fail to notify, yeah, Doug Weinstein think he's slick. You're not slick, Mr. Weinstein. I see what you're trying to say. Anyway, not only did Chief Judge Glanville fail to notify defense counsel about the ex parte proceedings as required by Rule 2.9, but Chief Judge Glanville made every effort to conceal the proceedings. Glanville should not have coerced sworn witness Lil Woody to testify. We know that. We'll keep it moving. We got a few more pages to get through, y'all, and then I want to hear your thoughts. As in Webb, the court can't repair the infringement of Kendrick's due process under the 14th Amendment, regardless of whether the violation was under Webb or when. I think, is it when or wine? Y'all have to let me know. Kendrick's rights were violated by the judge's intimidation and coercion of Lil Woody. As the state likely expected, Kendrick has been goaded into seeking a mistrial because of this due process violation and regretfully, all right now,
stop the cap,
request a mistrial. Wherefore, Kendrick respectfully and regretfully, again, request his honorable court to declare a mistrial based on the particular impossibility of avoiding the case after June 12, 2024, which he laid out and gave some great reasons for. The violation of Kendrick's rights by his being absented at a critical stage of the proceedings and or tainting the testimony of Lil Woody by the improper coercion of his testimony by Chief Judge Glanville. Yeah, Lil Woody said, I did these crimes, and the defense wasn't there. Y'all know they would have said, woo, they had interest. Furthermore, Kendrick respectfully requests this honorable court find that this request for mistrial was goaded by the state when it requested that Chief Judge Glanville hold the ex parte meeting, absented Kendrick from the meeting, and joined with Chief Judge Glanville in the coercion of Lil Woody. This, the 23rd day of July, 2024. All right, y'all, there it is. We got a little bit more information here. This is wild, man. This is wild. And we know there's at least two parties that would be interested in a mistrial. And as Mr. Weinstein so eloquently put it, they regretfully
stop the cap,
are going to have to request it. And that's Young Thug and Yak got it, as we see here. So I don't know what Judge Whitaker is going to do because, again, she's in Fulton County as well. Judge Rachel Krause, she did the right thing, but as you could see, she regretfully did it, and she didn't think Judge Glanville should have been removed. Is Judge Whitaker going to do the same thing? Because just looking at this as someone who is not a legal professional, I think we can clearly see that Glanville messed up in so many ways and really tainted this trial and tainted the jury, which is obviously even worse. So y'all let me know what you think in the comments and in the chat. Is this going to be thrown out? Is there going to be a mistrial? What would you do if you were Judge Whitaker? Let me know. Wow, we got a lot of comments in here. I told you, I'm hyped for this. I'm hyped for these motions, man. This is crazy. Absolutely crazy. Oh, look at them likes looking nice too. I see y'all. We've got 358 likes in the building. We got 470 of y'all watching. Thank y'all so much for watching. We've got some more motions to get to here in a second, and it's going to be crazy. We got 1, 2, 3, 4, 5, 6, 7, 8. 8 more of them. Let me see what y'all are saying in the chat real quick, and then we're going to keep it moving. Let me do this, and then we'll go back to our next one. What are y'all saying? The boss says there was a bunch of Brady violations in the ex parte, aka Brady bunch of them. Oh, come on now. I see what you did there, boss. Shout out to Floyd, the real deal. Neil is in here. He is out there with Papa Floyd. We've been praying for him. He's having some heart surgery, and Floyd's been giving us some updates. So he says stents doing their thing. No more chest pain. Praise God. He said, to God be the glory. Amen, man. We've been praying for him hard, and I'm glad to hear that he's doing well. Definitely keep us updated, and I'm glad that was successful, because heart surgery ain't no joke. So, all right, tell him to continue to recover. Do not tell him to take his recovery serious. So I'm glad that it went well, and I'm glad to hear that, brother. And we'll keep praying for a very speedy recovery as well. Roro's up in here saying can we get 464 out of 464 on them likes? Oh, we got Roro being greedy. I like it. Lauren Robinson said he did not hold back at all. Amy says, coming from my criminal justice background, I think this should be a mistrial. Amy, I want to see somebody argue it the other way. That would be fun. That would be fun to see if ADA Love decided to jump up here and she said, okay, this is why they're wrong. I'm not seeing it. We were totally fine to do that. I mean, you have so much of this. It's so easy to understand. We go back and look at, what was it, 2.9? Georgia Code of Judicial Conduct 2.9. This right here, there's nothing to me that says there was an exception at all. I'm with you, Amy. 1000%. El Papicito says this entire case needs to be moved from Fulton County or thrown out of judicial misconduct, prosecutor misconduct. The list goes on and on. It's crazy. Oh, we got K Cooper up in here. What's up, K Cooper? Thunder Drops in the building. Said they're going to throw the whole case out. Just my opinion. I agree. Let me go ahead and put the poll in the chat. Will the YSL I'm going to put a poll in the chat and see what y'all think. Will the YSL RICO case be a mistrial? Let me know, man. Court of public opinion. We got to hear from y'all. Shout out to Thunder Drop. Appreciate you stopping by. We got Tamoris Mickles is up in here, said they're going to get mistrial, but I think they're going to beat the whole case if they keep going. I mean, the state is handing them a win, in my opinion. I'm with you, man. I'm with you. Oh, it looks like we have somebody that called in. It's Floyd, the real deal. Neil, hold on a second. Let me go ahead and get Floyd up in here, and then we'll get into our next topic. Let me see if you can hear me. Let's see. It says no audio, so I got to switch this thing. All right, Floyd should be able to hear me now. Floyd, can you hear me?
Yeah, can you hear me?
There he is. Oh, yeah. Super clean. All right, man. What is on your mind, brother? Go ahead.
What is on your mind, brother? Go ahead. Hey, I feel like this right here. They need to a public apology to all of the taxpaying citizens in that area because they wasting y'all time and money with this, man. Thing about it is the mistrial, I don't feel like it's going to come without prejudice. They're going to be able to come back up. But at this point, man, I might as well just let that man up out of there and let him go ahead. And I guess if you can put surveillance on him to catch him with something else, because this one here is a wash.
Yeah, tell him, man, I want my money back.
Hey, bruh, y'all sitting up here talking about all this. We got a whole lot of other situations going on. And right now, y'all wasting folks' time and money because there's no way that y'all can literally expect people to have faith in the justice system, which they already don't. Whenever y'all behaving like this, y'all got these folk up here just moving and grooving how they want. The other judge over there pushing on police officers and bringing folks into the courthouses for weddings how she want to. Like, y'all got to teach these judges, if y'all going to be in that place of power, y'all still have to operate in integrity. And like I said, if y'all go back and read that 2.9 and actually read the exceptions, it just put the nail in the coffin.
Absolutely. And I think it's great, too, that the public eye and that the court of public opinion is getting to see this. In some cases, it can kind of go one way or the other. But I think specifically when it comes to the judges just total disregard for doing his duty. I think it needs to be shown. It needs to be seen. So I'm glad all the information's out there, and I'm with you 1000%, man. I want my refund.
Yeah, that boy, he was out there acting like the HNIC, but this go to show right here.
Yep.
Folks don't read, man. Wise man once said, "You want to hide something from a black man, put it in a book."
Talk
And
to him.
I think that statement is applicable to everybody nowadays. We in this generation, this time frame where it's a sunbeam mentality. Everybody just want it straight out the microwave quick. Now sit down, go to La Cordon Bleu, learn the processes, read through what you need to so that you can understand whenever something ain't looking like it's supposed to, and you'll benefit a lot greater. And kind of in that same lane, just like with this subject, but on another subject, when we talk about even with this election, you got to listen to both sides. Like, regardless if you like this person, don't like this person, sit down and listen to what's being said so that you just ain't going off the opinions of everybody else. That's one thing that I appreciate about this show, the way you sit down and you take the time to read through it so that people can actually gain an understanding instead of just going off of what he said, she said, they said. No, develop your own opinion, because it's us bringing our gifts, our thoughts to the table, which leads to America being able to have a great outcome, or just any situation, any business having a great outcome. It's the valuable opinions of everybody else that they developed on their own.
Yep, absolutely, man. Very well said. And that's why we're here, because I want to understand it. I enjoy and understand the importance of learning and understanding the laws and how the system works. And I just thought I would share that with y'all. So I'm thankful to be able to do it. And I appreciate you being here to support as well, man.
Hey, absolutely, man. Y'all appreciate it. Hey, hit that like button. Make sure that y'all hit that subscribe button. And if you love it like that, really go ahead and get a membership, because it's worth it.
Hey, there you go, man. Shout out to Floyd. Hey, we are praying for Pops. I'm glad to hear that he's doing well, man. Make sure you keep
He
us
doing
updated.
good, bro.
Yeah.
Before I go, let me tell y'all this. I ain't gonna lie.
Go ahead.
I had to think about it, because whenever he got out the hospital or got back to his room, it was about 4 o'clock in the afternoon. These folks was talking about releasing at 9 o'clock the next morning. And I had to pause because I'm sitting up there, I'm frustrated. Like, how you have a major surgery, 3 stents, and they talking about releasing you, it ain't even been 24 hours. Then it dawned on me, hey, bro, this what you prayed for. And if God gonna work it out to where he can get out in that time frame and move her and groove, do what he need to do,
Yeah.
hey, to God be the glory. We're just gonna celebrate it. So yeah, he at the highs, he chilling, man. Everything is great. So I appreciate all the prayers and support from y'all too.
Absolutely, man. It's a blessing. I'm glad to hear that. And I'm going to keep harassing you about it for the next while until we hear that he's out there running a mile in under 5 minutes. All right.
Already.
All right. Shout out to Floyd, man. I appreciate you, brother.
Salute.
All right. That is Floyd, the real deal Neil, aka Pretty Boy Floyd, up in here, always showing major love, supporting the community, supporting the channel. And yeah, you can call in anytime, man. You know it. Shout out to Floyd. What does Amy say? She said, thank you everyone for the likes. Please consider sharing this live with your friends, your neighbors, your family, and your coworkers, your baby mama, your baby daddy, your ex, and stalkers. God dang, Amy. You trying to get some people caught up. Don't do that. But yeah. Shout out to Amy. I appreciate it. Roro's in here. We'll get a couple more comments. And then again, y'all, we got so many of these motions to get to. I want to get to the next one. Roro says, Fawny, aka Funny Farm Willis, aka Gorilla Grip, should be ashamed of unethical self. Entire office sleeps around like the hand on a clock. God dang. Roro knows something that we don't know. I mean, we pretty much know. Y'all saw the text messages between her and Nathan Wade. So shout out to Fanny. What Roro say? Fawny, aka Funny Farm Willis, should be ashamed. Unethical self. God dang. Carolyn Janice says the criminal justice system is definitely broken. Yeah, and I think we just want a fair trial. Somebody mentioned in the comments of one of the videos, they said, oh, you're pro Young Thug. I said, no, but I'm not pro Young Thug. I'm not pro the state. But this trial has been a sham. It's just been a circus. It's been a gross injustice. Constitutional rights are being broken. It's just, yeah. So if you want to call me pro Young Thug at this point, I'm cool with it, because I don't want to hear anything the prosecution has to say at this point, especially if it's ADA Love and ADA Hilton up there. We got Glanville up out of there, but we know Fannie Willis has her eye and is looking at everything. So nah, I don't see how anyone could say that they're doing their job or doing the right thing. That's crazy. Satin is in here. Shout out to Satin. Says, I do agree with the mistrial. What I would hate to see Love, Hilton, and Glanville be questioned on the witness stand where they drilled Woody. Oh my gosh.
What did he say?
No, you need to rephrase that, Satin, but I get what you're saying. Why would you hate to see that, Satin? You think they're going to be able to handle themselves on the stand pretty well? Yeah, let me know. I'll be interested to see. Shout out to Roro, says, go, 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 likers. I see some different than classy beats. Great, Floyd. Amy says, I'm sure it's someone's baby daddy. Oh, y'all are talking about Amy. Amy was going wild over there. Mixed Chick Samantha says, Fanny looks at everybody that ain't her. Fanny looks at everything that ain't her job.
Hey, yo.
Dang. I'm with Boss on this one. Boss, I would love to see Brian Steele versus Judge Glanville, or Brian Steele versus Miss Love. Brian Steele versus ADA Hilton. Oh, of course, I turned up my phone. My bad, y'all. All right, we get a couple more comments. We got to get on to our next one. We're going to leave there. Got it. Variant says he wants it to end, but wants to see them on the stage. Yeah, I know. Isn't that terrible? I want it to be over, but I think because we're not going to get that public apology that Floyd was talking about, I just want to see them get on the stand and squirm and admit to some of the things that they did. That's the only reason I say that. The content's great and I love being here and talking about it, but we got to understand that people's real lives are affected by this, and what we're seeing is not justice. Illuminati says, if this is a mistrial, I can see lawsuits versus the state of Georgia coming. So I'm not sure they will stop trying. Yeah, Young Thug needs to go ahead and get him. All right, what did y'all say? I think we got enough votes in there. Now I'll leave it for the rest of the show. How about that? Unless I think of another one that we want to do. All right, so we've got, this one's going to be pretty quick. I think this one's only 5 pages, so we'll read through it real quick and address a couple of things that are said here. But we've got Shannon Stillwell, aka SB. He's filing a motion as well. We're going to check this one out. Again, a lot of these attorneys, I should say a lot of these defendants and their representation are trying to get this case shut down because it's been absolutely disgusting. But we'll go ahead and get into it here in a second. Here we go. To Judge Whitaker, this is a motion for a fair and constitutional trial. Comes now, Mr. Shannon Stillwell, aka SB. We're going to call him SB for the rest of this one. By and through undersigned counsel, and hereby files this motion for fair and constitutional trial in the above styled case. In support of this motion, SB shows as follows. SB is accused of multiple felonies, including conspiracy to violate the Georgia RICO law and substantive felonies in this indictment. Mr. SB is factually innocent of the charges against him. All right. And if y'all want to know who his representation is, there's a gentleman that we saw in the status update from Judge from Judge Whitaker on Monday. And he was the gentleman that was saying, hey, I think Lil Woody's testimony should be thrown out because some of the things that were said by him shouldn't have been heard. And there was everything that went down on June 12th. So we need to consider getting rid of Lil Woody's testimony. So that's the gentleman who's representing SB, aka Shannon Stillwell. Right. Like all citizens, SB is guaranteed a fair trial and due process at trial by the federal and state constitutions, the Confrontation Clause, the Due Process Clause, and all other constitutional protections. SB deems that his trial be conducted in a fair and constitutional manner. The state is seeking a life without parole sentence for Mr. Stillwell if he is convicted. My goodness. And I said I was going to call him SB. And SB's constitutional rights must be protected without exception. I think we all agree. SB and his co-defendants have been in trial for approximately 19 months. Whew. Approximately 75 witnesses have testified so far. SB has remained in jail for the duration of this trial. Judge Ural Glanville has been the trial judge to this point. This case has been plagued by discovery violations, lost and missing police reports. What? And Brady violations, as we saw in the ex parte meeting. The defense also takes issue with several of Judge Glanville's legal rulings, including but not limited to an overly liberal and unconstitutional application of OCGA 801D, 2, and E. Most recently, Fulton County District Attorneys Hilton and Love took part in an ex parte meeting with Judge Glanville. This meeting also included witness Lil Woody and Lil Woody's attorney, Caleb Bumpus. Neither SB nor undersigned counsel were informed of or invited to attend this meeting. The same is true for all of SB's confidants and their counsels. Let's see here. We're going with Yak Gotti filed a motion to recuse Judge Glanville on June 12, 2024. We just talked about it. Judge Glanville summarily denied said motion. Yak Gotti's motion to recuse, as well as a similar motion filed by co-defendants Young Thug, aka the Honorable Brian Steele, were subsequently considered and granted by the Honorable Judge Rachel Krause. There goes the Honorable again. Did he put Honorable in front of Judge Glanville? What? Sure didn't. Dang. Young Thug, through his attorney, has since filed a motion for a fair trial on July 10th, 2024. Young Thug's motion alleges and discusses several ways in which this trial has been unfair and has failed to meet constitutional requirements for Young Thug. Yak Gotti, through his attorney, has also filed a similar motion on July 23rd. So they were talking, man. Y'all see this? They filed this at almost the same time. Let me see when his was filed. His was filed at 3:07 on the 23rd. When was this one filed? Oh, 11 a.m. So Weinstein called Mr. Sharks and said, hey, we're about to file this thing. You want to take a look at it so you can get your motion for fair trial put together? He said, yeah, send that over, man. Appreciate you. Where were we at? Page 2. Here we go. Okay, yep. Yak Gotti, through his attorney, also filed a similar motion on July 23rd, 2024. Mr. Stillwell adopts both motions and incorporates their contents into this motion. As SB has similarly affected or has been similarly affected by the errors in this case. SB does not wish to demand a mistrial, absent jeopardy attaching. SB has been incarcerated since and has suffered through the duration of this case. I wonder, that's interesting that SB is staying out of the mistrial. Very interesting. I wonder why they're taking this angle. Maybe they're all working together and they're all taking every single angle they can to get this case thrown out. So they don't want to pile on. I don't know. If one of the lawyers in the chat and one of the lawyers in the community wants to comment, or y'all let me know in the chat why he would be taking this route. I think it'll be interesting to hear from y'all. SB has been incarcerated since and has suffered through the duration of this case. Starting the trial all over again is not a viable option for SB. Furthermore, the defense has completely neutralized all testimony and documentary evidence presented against SB thus far. In other words, the defense is winning this trial. Interesting for him to say. The defense is winning despite the persistent legal errors, Brady violations, ex parte meetings, and discovery issues that have plagued this case. SB does not request to start this case over. I wouldn't want to either. I don't blame him. Nonetheless, serious errors have tainted this trial and continue to prohibit SB from receiving a fair trial and from confronting witnesses called against him. SB's due process rights have been and continue to be violated. These errors, as described in detail in Young Thug and Yak Gotti's motions, have been caused solely by Fulton County's District Attorney's Office and Judge Glanville. Fannie Willis, she needs to say something about this. I don't see. She probably won't, though. The errors cannot be cured by curative instructions and will ultimately prevent these proceedings from meeting federal and state constitutional requirements. Yeah, it was nice of Judge Whitaker to have her little status update and say, hey guys, let's all work together. Let's just have a good time. You know, y'all know what I'm saying. You guys need something from the defense, just help them out. Prosecutions, they need something from you. And guess what? We're going to take care of the witness list and everything for you. And it's going to be all nice. Nope. What? He said, that's not going to work. Talking time is over. They've done enough. There's been too much damage. It's time to move on, right? What does this note say too? SB specifically incorporates past and future filings on behalf of co-defendant Young Thug and Yak Gotti and the list of legal errors, prosecutorial misconduct, Brady violations, discovery violations, and other legal arguments included therein. These errors cannot be cured by curative instructions and will ultimately prevent the proceedings from meeting federal and state constitutional requirements, adhering to the Georgia rule of evidence, and filing the requirements of Brady. Yeah, if they could, man, if this goes to the Georgia Supreme Court, I could see them dropping the hammer on this, honestly. And we know that they're watching. We know they're keeping an eye on things, but I'm sure they're hoping that this could be taken care of at the local level. Because if you look at some of the stuff they're saying throughout these motions, it's pretty serious. And if they're smart, they'll do what Judge Whitaker said, try and get some more pleas out before everything starts to roll downhill. Wherefore, undersigned counsel respectfully requests this court considers Mr. Stillwell's, aka SB's, arguments and issues an order which will fully and adequately protect SB's constitutional rights. And then we got Mr. Max Shart up in here. Shout out to him. He actually has done a couple of, or maybe he just did one interview. But yeah, sounds like a super cool dude, and he's up there working for his client. But we do have another motion from him, so we're going to combine these two together. So this second motion he filed right at the same time. Y'all see, if we go to the top of this one filed at 305 or 307, this one at 307. What is this one? Motion for reconsidering regarding certain hearsay statements. Now, this is going to get into what I mentioned earlier, where he's talking about Lil Woody being on the stand and some of his testimony and how that would affect his client SB from getting a fair trial. All right, comes now SB versus the state of Georgia. This is a letter to Judge Whitaker. Comes now SB by and through undersigned counsel hereby files this motion for reconsideration in the above styled case. In support of this motion, SB shows as follows. And this is another quick one, y'all. SB is accused of multiple felonies, including count 1, conspiracy to violate the Georgia RICO law, and specific substantive felonies. SB is innocent of all charges against him. SB is charged with the January 2015 alleged murder of Donovan Thomas, aka Big Nut. Hey, yo. And count 2 of this indictment, SB is innocent of all that charge as well. Lil Woody, a witness called by the state, is currently on the witness stand. He's still a sworn. Boy, oh boy, this is just everything we talk. I know I'm beating a dead horse here, but everything we talked about when it comes to them making content, Lil Woody is out here going wild and crazy and getting so much content out. It's just crazy to hear them say that he's currently on the witness stand. Think about that for a second. Anyway, I digress. Lil Woody has never claimed to have any firsthand knowledge regarding the death of Big Nut. Lil Woody did, however, meet with law enforcement several times in 2015. On June 10th, 2015, and what Lil Woody's Fifth Amendment law, and what was Lil Woody's fifth meeting, with law enforcement in 2015. He's trying to call him a snitch here. Hey, come on. Come on now, Mr. Sharks. You don't got to do him like that. Lil Woody told law enforcement that he possessed specific information regarding the shooting death of Big Nut. Lil Woody made this claim while under the threat of arrest from unrelated crimes that law enforcement was investigating, which, again, we talked about this. This is most likely where a lot of the information or his willingness to testify came from. Lil Woody did not mention this information on any of the 4 prior meetings with law enforcement. They're saying maybe somebody talked to him. In his June 10th, 2015 interview, Lil Woody told law enforcement that he picked up Damekion, I'm probably saying that wrong, Garlington at a McDonald's restaurant on Cleveland Avenue on the evening of January 10th, 2015. Lil Woody reported that Garlington walked to his Lil Woody's car. Okay, that was just a error there, I guess. And while the two men were briefly alone, Garlington told Lil Woody that they killed Nut. Okay, and we've got some notes here that we'll address in a second. Lil Woody told law enforcement that Garlington then pointed out a group of people who were pulling into the McDonald's. Lil Woody told law enforcement that he interrupted Garlington's words and actions to mean he interpreted, excuse me. Let me read that again. Copeland told law enforcement that he interpreted Garlington's words and actions to mean that SB, Yak Gotti, and Justin Cobb and Demise McMullen were all present for and all participated in a drive-by shooting of Big Nut. Dang. Dang. Per Lil Woody, Demise McMullen entered his car shortly after Garland, and all communication about the event ceased. So a little bit more background to what happened here. Basically, what they're showing is, which is crazy, there was a car that was rented. Who was the car rented by? Well, I'm going to let y'all look into and research that. But I think some people are saying Young Thug rented a car that was in the area of this shooting of Big Nut. They've been beefing back and forth. And allegedly, what happened in this situation is a lot of these guys who were mentioned in this motion, Justin Cobb, Yak Gotti, SB, they were all making phone calls back and forth to Thug. They make all these phone calls back and forth to Young Thug. Then the phone calls stop. Shortly after that, that is allegedly when Big Nut was killed. Then after that happens, more phone calls start going back to Young Thug. And this is where Lil Woody comes in. Then Lil Woody, he gets them. He meets them at the McDonald's after this, and they tell him what goes down, allegedly, according to his testimony. And then they actually went and met with Young Thug somewhere else, allegedly. So that's a little bit background about that situation. It's really kind of crazy, but we haven't really had a good chance to cover and listen to all of this because all of the other stuff that's been going on. Let's look at some of these notes here real quick. It should be noted that Mr. Garlington is charged in this indictment. Garlington was served from this trial as he remained unrepresented into the winter of 2022. Garlington is not expected to testify at this trial as his case is still pending. Nut and Peanut were Donovan Thomas's nicknames. Okay, so they just referenced that there. Thank y'all for that. Lil Woody, per Lil Woody, Demise entered his car shortly after Garlington, and all communication about the event ceased. Lil Woody is now a sworn witness for the state and is currently on the stand. This gets me every time. On direct examination thus far, Lil Woody has not denied making this June 2015 statement to law enforcement. Lil Woody has repudiated, I think is how that's said. Lil Woody has repudiated the contents and the veracity of this prior statement. However, Lil Woody's testified at trial that this conversation with Garlington never occurred and that Lil Woody fabricated the event to get himself out of trouble. Name dropping to get yourself out of trouble is wild. What do they call that? I'm not going to say anything. Lil Woody said this, y'all. I'm just reading what Lil Woody said. And this is what they're saying in this motion. Lil Woody testified at trial that this conversation he had with Garland never occurred and that Lil Woody fabricated the event to get himself out of legal trouble. That is wild. That is wild. Y'all know what that's called. Let me know what you think it's called in the comments. Furthermore, Lil Woody has denied contextual clues surrounding the out of court statement testifying that it was SB. Okay. Oh, let me move this back on the screen. There we go. And not Mr. McMullen, who got in the car with Lil Woody and Garlington that evening. SB challenged the admissibility of Garlington's out of court statements on hearsay and confrontation clause grounds. SB, through undersigned attorney, filed a motion to limine on this matter on September 30th, 2022. Judge Glanville eventually considered brief argument and ruled on the admissibility of the statements. Defense counsel was unable to locate a written order regarding the admissibility of Garlington's alleged statements. Judge Glanville, who has since been recused from the case, this is an important point, ruled that these statements were admissible as statements of a co-conspirator. This ruling does not comport with the U.S. Constitution or the Georgia Rules of Evidence. The plain text in 24-8-0801 requires not only that the proponent of evidence establish the existence of the conspiracy, which I don't think anybody other than Lil Woody is going to back up, and show that the statement was made during the pendency of the conspiracy, but that the proponent must also, okay, so he would have, interesting, establish that the statement was made in furtherance of the conspiracy. Assuming that Garlington actually said these things to Lil Woody, these statements were not made in the furtherance of the conspiracy. The job was done. That's true. To find otherwise simply overlooks, disregards the plain language of 24-8-801. And the line of controlling cases that establish that statement that spill the beans by definition do not further a conspiracy. Yeah, hey, you know what I heard happen? Or this is what I heard? Is that you're not going to be able to use that. The state plans to elicit testimony from Lil Woody regarding Garlington's alleged statements, while Lil Woody is now denying that Garlington has made any such statements. Lil Woody has openly acknowledged that he previously told law enforcement that Garland made said statements. So what he's saying is Lil Woody said 3 times before I'm not going to say it, before he gave them some names. He said 3 times before that, hey, listen, I don't know. And then he came back the 4th time after, I think what is alleged is that he was pressured in some way. After that, he came back and he said, okay, this is what I think happened. Y'all have a good day. Can I leave now? Tough situation to be in. The state plans to elicit testimony from Lil Woody regarding Garlington's alleged statements, while Lil Woody is now denying that Garlington made any such statements. Lil Woody has openly acknowledged that he previously told law enforcement that Garland made said statements. Are y'all going to forgive somebody who does this to you? Let me know in the comments. The state has attempted to improperly introduce the contents of Garland's statement through recordings of Lil Woody's prior statements, including June 10th, 2015 interview. Yep. The state's method is improper for 2 reasons. First, Lil Woody has not denied making these prior statements, and therefore no foundation for prior inconsistent statements has been laid. That's a great point. Second, which is the focus of the motion, Garlington's statements to Lil Woody, even if uttered, were not made in furtherance of the conspiracy and therefore failed to meet the requirements of 24-8-801. Which I didn't know this, so I'm learning something here too. I'm not gonna pull up 24-8-801 for y'all, but I'm gonna go and look at it on my own time and kind of interpret it and see what it means, because it's interesting that that even if you make the statement after the alleged conspiracy happens, that's not something that's admissible, which is what SB is saying here. Wherefore, undersigned counsel respectfully requests this court considers Mr. Stillwell's argument and reconsiders whether the state has met their burden in establishing that Garland's alleged statements satisfy the requirement of 24801. Okay. And then that's it. That's it on that one. Y'all have to let me know what you think about this entire situation. Do you think they're going to be able to get rid of Lil Woody's testimony? It seems like there's evidence to show that. And are they going to give Mr. Garland up here a break? I don't know. Y'all tell me. Let me see what the chat is saying in here too. We still got over 400 people in the building and we've got 492 likes. That's what I'm talking about. Thank y'all for liking the video. Again, likes are the #1 way you can support this channel. I appreciate it. And I thank y'all as well. Let me see what y'all are saying in the comments and then we'll get into our next one. This one's going to be a good one because we got our guy, Mr. Brian Steele, back at it. This is going to be a fun one. All right, let me see. Let me double check this. Funnies, crew. Let me see here. Okay. I got it. So this is going to be the next one. Let's check the comments. Also, I'm going to pull up the call log and see if anybody wanted to call in and address what we just talked about. Boss was in here, said, I think Lil Woody's testimony is toast. Just as I vote, I like early and often. Thank you, man. Shout out to Boss. I appreciate you. What else are y'all saying? Amy says, Boss, I'm sure some do. Oh, I have to go backwards. I own my own business. Oh, okay. Y'all are talking about something else. Let me see. Mixed Chick Samantha says, I talked to Rebecca, the female that called in. Oh, Kayla was really talking ish. Talk about bruh, this and that, and then called, said, you like Glanville? I was like, dang. Oh man, y'all can keep that drama. Mr. El Papicito says, loving your commentary, beautiful Amy. Are you a content creator on YouTube? We're trying to get her in there. Shout out to Amy. She be putting in work in the chat, man. I appreciate it. I really do. Beth Davis says, Amy, how do you feel about Miss Love? I can't stand Miss Love or Miss Hilton. I hope that new judge isn't going to have Miss Love out talk her. What do you think, Amy? Man, we got Amy having her own show in the comments. I love it. Their periods were in sync. What? Why did I read that out loud? I got to read these comments, man, before I put them up on the screen. Y'all are wild. Wow. All right, we're going to keep it moving. Let me get a couple. Oh my God, look at him. My guy, the lead attorney is in the building. Salute to the lead. I told y'all at the beginning of this live stream, you need to go watch this man. Go subscribe. Every single video, every single live stream he drops gives so much wisdom from his 20+ years of experience as an attorney. And he's putting in the work out here on these YouTube streets. Y'all go show the lead attorney some love. If one of the mods could drop a link to his channel in the comments and in the chat, I would appreciate it. And I've actually covered a couple of the reviews and videos that he's done as well. So appreciate you being here, lead man. Shout out to him. And he did an amazing live stream last night with AV that I finished watching earlier this morning. So y'all go check that one out, because he did an amazing job of breaking down one of the motions we're going to get into a little bit later. All right, everybody loves TLA. Y'all saying TLA in the house, TLA in the house. Appreciate you stopping by, lead. That means a lot, for real. Boss says, ClassE, did you take TLA's course on streaming? No, I need to though. I have not taken it yet, but I be out here struggle streaming sometimes. Y'all see it. Shout out to the lead attorney, man. I appreciate you. All right. And thank you to Amy for dropping the link to TLA's channel in the chat. And y'all go join the memberships over there too, if you haven't done that yet. Also, make sure you go check out AV to the 7th Power. She's doing some great content on her own as well. So we're having a lot of fun. All right, leads in the building. So I got to straighten up, y'all. I'm trying, lead. I'm out here trying. We're talking about it from layman's turn. So I got to get it together. Varian is in here, says, I swear I thought you took lead's course. No, I need to though. Y'all could drop the link to lead attorney's course in the chat too. If y'all are thinking about getting into live stream, as I mentioned again at the beginning of the show, lead attorney is the best in the game. He has the best live streaming course that's available. So if y'all want to learn about live streaming, that's the place to do it. But go check him out. You'll be able to find it, and y'all can drop it in the comments too. But yeah, I need to practice what I preach and go ahead and take that course. Mixed Chick Samantha says, TLA, can you give ClassE what he didn't use? What do you mean? What are you talking about, Mixed Chick Samantha? Yeah, shout out to Amy. I appreciate you. All right, y'all ready to go ahead and get into this next one? This one's going to be another fun one. I need to make sure and double check I've got everything in here. Motions to exclude. And then we've got this one. Okay, yeah. We're good to go. We got it in here. And again, if y'all want to call in, the link to call in is in the description. It's also in the pinned comment in the chat. Y'all can give a call in. Let me know what you think as soon as we get done covering this next topic. I'm going to bring some more of y'all up here. All right, this next one, y'all know what time it is. The attorney of the year, the Honorable Judge Brian Steele is back at it. And y'all know when Brian Steele walks in the building, it's about to go down. So we've got another motion from Young Thug, aka Brian Steele. And this motion is a state's motion to exclude victim character evidence. We're going to get into it and talk a little bit about some of the things that are being said, some of the things that they want to get rid of, what's going on. All right, here we go. Jeffrey Williams, aka Young Thug, versus the state of Georgia. This is another letter to Judge Whitaker. It says the state's motion to exclude victim character evidence. Introduction. The state believes the defendants in the above styled case may attempt to improperly place the character of the deceased victim, Big Nut, aka Donovan Thomas, aka Peanut, aka Nut, in issue at the trial of this case. For the reasons stated below, the state moves this court prohibit any attempt by the defendants to elicit and introduce improper character evidence as prohibited. Okay, so y'all check this out. Defendants DeMonte Kendrick and SB, so that's Yak Got It and SB, are charged in count 2 with the January 10th, 2015 murder of Big Nut, aka Donovan Thomas Jr. over acts. Conspiracy to violate the Racketeer Influence and Corruption Acts also pertain to the murder of Big Nut. The defendants have pled not guilty to both count 1 and count 2 and have never raised or asserted any claim of self-defense. Interesting. Now, I want to go back into a little bit of the background, but let's keep moving through this. And here's the argument and citation of authority. All right. Georgia evidentiary states in 244404 and 244405 that govern admissibility of a victim's character. These statutes generally limit evidence of the victim's character to reputation or opinion and not specific bad acts. Okay. And again, basically what they're trying to say here is that Brian Steele is going to try and paint Big Nut in a bad light, or I should say the defense, right? They're going to try and say that Big Nut, this is the bad guy. He did all these things. He was affiliated. He was out here trying to kill people and all this other stuff. So that's basically what the state is trying to say here, right? And then provides in permanent part as follows: evidence of a person's character or trait character shall not be admissible for the purpose of proving action in conformity therein on a particular occasion. There are 3 enumerated exceptions in 24,404. Pertinent trait of character offered by a party to rebut the same. Evidence of a victim's character trait for peacefulness to rebut evidence that victim was initial aggressor. Evidence of the character of a witness. Where evidence of a character or trait of a person is admissible, proof shall be made by testimony as to reputation or testimony in the form of an opinion. Generally, a murder victim's character is irrelevant and inadmissible. Yeah, I mean, I guess he can't really defend himself, so that's kind of tough there. Rest in peace. A victim's character may only be admitted if there exists some factual nexus to the conclusion for which it is being offered. Goodness, that is a factual nexus. I'm gonna have to look up what they mean there. It is impermissible to establish such a nexus through sheer speculation. Yeah, he gone. So even if cases were an accused in arguing self-defense, the accused may only seek to introduce evidence of the victim's violent character through the admission of reputation and opinion testimony. No factual nexus to the admission of victim's character. The character of Donovan Thomas Jr., aka Big Nut, is irrelevant and inadmissible in this trial because there exists no factual nexus for introducing any evidence pertaining to his character. Furthermore, any evidence of the victim's violent character is unequivocally irrelevant because no defendant has claimed self-defense. Finally, even if the court were to find a relevant purpose for the victim's character evidence, it could only permit admission through reputation and opinion testimony, not specific acts. Which is interesting. They're trying to say Nut was, I get what they're saying from a legal standpoint, but still we'll have to go back and see why Brian Steele was saying we need to get this in here. The state requests this court to prohibit the defense from intentionally or inadvertently elicit improper character evidence. And this is by Adrian Love. So this is one of the first things that we're seeing from the state. And it's going to be interesting to see what Judge Whitaker does in response to this. I'm trying to see, y'all bear with me for a second, if I can go back and find where Brian Steele was mentioning this. This is not the one. This is over on X. So y'all bear with me one second. So this is the motion. I'm trying to find it, but I may have to come back to this one. So the state filed this yesterday afternoon at 4:32. Again, Judge Whitaker, she's going to have a lot on her plate to see how they respond to this, because I think this is going to be a big part of the defense building their case when it comes to what happened in this entire situation, including with Lil Woody getting kicked out of there too. All right, so let me get to this next one real quick. This is another motion that was filed by, I'm going to mess up his name, Quamervius Nichols. And this is a motion for mistrial and objection to mid-trial substitution of the trial judge. This is going to be an interesting one too, but let me see what y'all are saying in the chat. Oh, shout out to Amy for dropping the link to TLA's course. If you're interested in live streaming, you want to know how to get started, go check out TLA's course. He has the #1 course on live streaming anywhere. So y'all go check him out. Show him some love. Oh, Mixed Chick Samantha says, I'm just saying, Lauren, when he didn't use the courses, ClassE would for sure use them. I love lead. In his words, Kayla fied. He retired. Shout out to Mixed Chick Samantha. Boss said, I just said Judge Brian Steele. We're going to pretend like that didn't happen. What else are y'all saying? El Papicito says, Mixed Chick Samantha, I'm sure Woody will not use TLA's course. He's too busy on his hustle. Woody is a straight up street ninja. Yeah, he's out there getting it, man. And this guy's still on the stand, which is crazy to me. Mixed Chick Samantha says, I'm not even in the legal field, but this seems impossible for the judge to take this case on. Please correct me if I'm wrong. I mean, you're allowed to use common sense, Mixed Chick Samantha. So using common sense isn't a crime. And if you were on these juries, you would have to do that already. So use your common sense, look at the evidence that's presented, and hey, let me know what you think. Shout out to Roro, says lead is fire. Yeah, lead is that dude. Boss says, I wonder who's been on the stand the longest for a case in Georgia. Ooh, that's a good question. We could probably get Chat GBT up here and figure it out. Let me see if anybody wanted to call in too. I don't see anybody back there. Again, if y'all want to call in, let me know. We got several more of these to get to. Several more. Well, how many did I say? 1, 2, 3, 4, 5 up in here. This one's going to be quick. Then we've got Brian Steele. We're going to find out what he's talking about because he's asking for bond for Young Thug. And he's also, let me see. There's going to be a response from the state here as well. So let's see. Amy said, comment, what? Yeah, I knew somebody was going to say that. We're at 511 likes again. Thank y'all for liking the video. It really does help the channel continue to grow, and it's free. Lets the algorithm know you guys are enjoying the show, and it shares it with more people. All right, so thank y'all so much for this. Let's go and see if I got everybody in the comments. All right. I think we're doing pretty good. I'm probably going to combine these two because I really want to get to what Brian Steele is saying. Y'all check this one out. Let's go ahead and get this next motion in here. So we have another motion that is filed, and it's being filed. We're going to call him Q. We're going to call him Q Nichols is the defendant. And this motion is for a mistrial and objection to mid-trial substitution of the trial judge. And this one's going to be a fun one because I want to talk about, we'll talk about the person who wrote this up in a minute, but y'all check it out. Let's get into it and see what's going on here. Comes now the defendant, Q Nichols, and shout out to see, I should have just left it alone. Q Nichols by and through underside counsel and files this motion for mistrial in the above captioned case. In support of this motion, Mr. Nichols shows the court as follows. Mr. Nichols adopts all motions and arguments for a mistrial as filed by co-defendants. If such motions are denied, Nichols further moves for mistrial and objects to mid-trial substitution for the following reasons. I think y'all could probably guess what some of them are, but let's see what Mr. Nichols is saying here. Mr. Nichols moves for a mistrial and objects to mid-trial substitutions to the trial judge because here, for a judge to be substituted after 19 months of the trial, including 6 months of testimony. Oh my God. The admission of evidence prejudices, I'm still saying it wrong, the defendant's right to a fair trial under the 6th and 14th Amendments of the United States Constitution, as well as the provisions of the Constitution of the state of Georgia, which that is pretty easy to see. How in the world are we going to be able to move through this case successfully with 19 months have gone by and 6 months of testimony? And Judge Glanville was saying that we're not even through half of the testimonies. My God, man, get me out of here. Further, Mr. Nichols moves for a mistrial and objects to mid-trial substitution of the trial judge because the current the current presiding judge was not the judge during the last 19 months of the trial. When, for example, Mr. Nichols moves for a direct verdict, this court will be unable to adequately examine the entirety of the prior proceedings in order to rule on the request. Yeah, I don't think Judge Whitaker, from what we heard from her, she wants to go back and look at all that. She said, hey, y'all, we're just going to move forward from either June 10th or June 12th, or I'm sorry, June 10th or June 12th. And then we're going to keep it going from there. So I don't want to go back and unwind all this stuff. We'll start at this point. And Mr. Nichols is saying, no, because if I have some things I want to do later on in the case, you're going to have to go back and look at some of these other things that happened during these 19 months. Of the 19 months of the trial, over 6 months have been testimony for which the court has not presented and therefore cannot base its decision on what has occurred during trial. Additionally, Mr. Nichols moves for mistrial and objects to mid-trial substitution of the trial judge because on Friday, July 18th, this court advised the parties that she was unfamiliar with the previous trial proceedings.
Stop the cap.
We ain't not buying that. That have occurred over the last year and a half. During the trial, before the court became the president court, Judge Glanville made several contingent decisions, noting that he would revisit his rulings as trial proceeded. These contingent rulings covered several aspects of the tentative admissibility of evidence. Given the fact that the current court is unfamiliar with over 6 months worth of testimony, arguments by the parties, motions by the parties, and contingent rulings, this court cannot possibly make decisions based on what has occurred, which the court was not privy to, nor has reviewed the record. And this is exactly what Judge Whitaker said she wanted to avoid during her status meetings. She said, hey, y'all, I want to move this case forward. Prosecution, if y'all can work out some plea deals, please make that happen. Y'all make sure you work together. Let's make this as smooth as possible. Mr. Nichols is saying that can't happen, Judge, because when I talk about something Judge Glanville said or something that was said during this 6 months of testimony, you're not going to know what I'm talking about because you haven't been following the case. It's a mess. It's a whole mess. Mr. Nichols further moves for a mistrial and objects to mid-trial substitution of the trial judge because Nichols specifically on several occasions during the trial moved the court to give curative rule 105, which we'll have to look up and read, instructions. The court denied each request to give such instruction at the time, but indicated it may be necessary to give at a later time or at the end of the trial. Well, Glanville's gone, so I don't know how that's going to happen. Mr. Nichols also moved the court for a severance on multiple occasions, which the court denied at the time, but agreed that a time may come that the issue would need to be revisited. So this is interesting because it seems like Mr. Nichols is kind of putting the heat a little bit on Judge Whitaker and giving a little bit of pushback because of what we said. He's saying, hey, you're basically picking up for Judge Glanville. You can't just start at June 10th or 12th. You're going to have to go back and review and unwind everything, even though you said you didn't want to. So it's on you, Judge. You got to do the right thing. Throw this out. Crazy. He's got an experienced lawyer too. This court would now need the benefit of the 6 months worth of previous testimony to adequately and fairly make decisions regarding whether an instruction or a severance is warranted. Given the court is unfamiliar with the trial proceedings and has indicated that it did not intend on familiarizing itself with the trial proceedings. Again, we just mentioned, she said that Mr. Nichols' constitutional rights are violated because this court cannot make uninformed rulings based on the record. Trials evolve and decisions are made by the court based in part to the way the trial and the evidence play out over time. Yeah, if someone's playing chess with another person and you try and jump into the middle of the game and take over for them, how could you know what moves they were planning on making? Because chess is a game like that. You have to be ahead of each move that you're going to make. How can you know what moves were going to be made or see where things were going? It's going to mess up the whole thing. Trials evolve and decisions are made by the court based on, in part, on the way the trial and evidence play out over time. The court has missed crucial proceedings necessary to make fair and well-founded rulings and to properly instruct the jury both during and at the conclusion of the trial. Not to mention them calling our guy unprofessional and unprepared. Nichols moves for mistrial and objects to mid-trial substitution of the trial judge because the court has indicated that it does not intend on reviewing the complete record, including trial proceedings and litigation that have already occurred. For this court to step into the 19-month ongoing trial in which over 100 witnesses have already testified means that this court is proceeding with trial and unable to assess core trial functions such as the credibility of the witnesses that have already testified. Now let's read this note here. Nichols would contend that such a task would be impossible at this point, which is 1000% true. The lack of a trial court being being personally familiar with the record, but presiding over the continuation of this trial, making decisions regarding trial and instructing the jury violates Nichols' right to due process and a fair trial as guaranteed by our Constitution. Mr. Nichols further moves for mistrial and objects to mid-trial substitution of the trial judge because even if the court attempted to read the transcripts from the past 6 months worth of trial, that would not be adequate. That would not be an adequate substitute for the court observing live testimony. And then they mentioned during Judge Whitaker's status update that they have 8,000 jail calls that they have to go through. 8,000. I still couldn't believe that. Even if the court attempted to watch 6 months worth of trial proceedings via media recordings from afar, that would not be an adequate substitute for the court's personal and direct observations. Yeah, and you can't. If there was an argument to the contrary, Nichols notes that the media was not allowed to film several witnesses and at times were not recording due to technical difficulties. I remember when Lead was covering this and they had everything all jacked up. That camera was struggling. Nichols moves for mistrial and objects to mid-trial substitution of the trial judge because trial has been suspended for over a month and jurors cannot reasonably be expected to just pick up where they left off with their memories and observations intact. Furthermore, a mid-trial substituted judge cannot adequately instruct the jury regarding previous proceedings, which the judge is unfamiliar with. Right, we got a couple more pages here. Further, Nichols reiterates and realleges his request for a severance and incorporates his previous arguments that an enormous amount of prejudicial spillover has already occurred and no jury could be expected to compartmentalize the evidence as it relates to the separate defendants and charges. Wherefore, the defendant moves this court for a hearing on the motion for mistrial and objection to the substitution of the trial judge. And who is his attorney? Bruce Harvey. The Honorable Bruce Harvey, the big dog. This man's been in law for years. And y'all even remember them mentioning the Harvey rule that Judge Glanville was going by during the status update. This is that dude. So it'll be interesting to see what happens here. I think this is the first motion that I've seen to where, I mean, the defendant is really putting the pressure on the judge to say, hey, judge, we're glad you're here. We appreciate you being willing to take this case, but there is no way in the world that you can possibly rule on this appropriately. And I think Bruce Harvey makes a great point. It's something we haven't talked about as much as we want to see a fair trial. And we think it's great that Judge Whitaker is willing to take this on. There's so much he doesn't know and hasn't seen that led us to where we are now, whether that's the attitude of the jury towards Brian Steele, maybe because of what Glanville said with him being unprofessional and unprepared, or whether that's the struggle that some of the defense was having to go through with getting certain things they needed in court. So it'll be interesting to see what happens with this. I think Judge Whitaker might take this one a little bit more personally. We'll have to see what happens. Y'all let me know what you think in the comments. Yeah, 8K is crazy. 8,000 jail calls. I mean, how did they collect all of those? I would be interested to see just their filing system of how they keep track of all these jail calls. I'm going to double check and see if anybody wanted to call in and give their thoughts too. We've got a few more of these to get through, y'all, and we're almost done. We're going to get into Mr. Brian Steele here in a second. And we've got the state responding as well. Let me make sure we're good and set to go. Yeah, here we go. So we've got, Amy says 8K. Yep. Mixed Chick Samantha says, get love and Hilton some alkaline water. Y'all need gotta be on that alkaline. You get one life, people. Take care of it. Shout out to Bobby Drake in here. Says, I done seen people win appeals for less. Thank you. All I've heard or seen, says El Papicito, says, all I've heard or seen comments about the defendant suing the state after the fact. That's not possible in most jurisdictions are immune from civil liability. That sucks. Dang. Yeah, see, that's something I didn't know. Boz says, you spoil us by interacting with the chat. Yeah, I'll have to go check out TLA's course. I got to get TLA's course because he's probably going to say, hey, stop reading all those comments in the chat. Just relax, man. Lauren Robinson says, and he is right. All lawyers are going ham. Yeah. Judge Whitaker, I'll be interested to see how she addresses this one. What does Amy say? Wealthy wisdom. The Trump rally shooter flew a drone about 200 yards from the rally venue. What? And had it up in the air for about 11 minutes, just hours before the shooting. Yeah, we're going to talk about that at some point and get back into our coverage of what's going on in politics, but that whole thing is absolutely wild and insane. All right, y'all ready to talk about our guy, Young Thug, and the Honorable Brian Steele? We'll get into it here in a second. So we got a renewed motion for bond and brief in support of pre-verdict bond. And this one is about 10 pages. And then we've got, let's see, this response from the state. We got a couple of responses from the state. Okay, cool. I want to make sure that we've got all these in order. This is going to be a good one. So Brian Steele, as we know, putting in work always for his guy, Young Thug. He is trying to get Young Thug out of here. And we're going to check out this motion that he just submitted on Tuesday, sorry. And he's trying to get his guy, Young Thug, bond. So let's see what he's saying and go ahead and get into it without wasting any more time. State of Georgia versus Young Thug, aka Jeffrey Williams. And this is a letter to Judge Whitaker. Renewed motion for bond and brief in support of pre-verdict bond. Comes now, defendant Young Thug, by and through undersigned counsel, and hereby files this renewed motion for bond and brief in support of pre-verdict bond in the above reference case. In support of this renewed motion for bond and brief, Young Thug shows the below. In the great state of Georgia, unlike other states, for purposes of pre-trial bond analysis, the presumption of innocence remains with the person accused of an offense. Innocent till proven guilty. I like it. Even a capital offense from arrest and even during trial. All right. See Voldemort versus Brand. I don't know how to say that name. That means prior to and during trial, courts view the criminally accused to be innocent and to be innocent of the charges waged against him or her. It has been written that the most fundamental premise of our criminal justice system is that the criminally accused cannot be punished for an offense until the prosecutors prove guilty beyond a reasonable doubt. Well, the court of public opinion would say otherwise, but I get what you're saying. Y'all saw what they did to our guy, Johnny Depp. It's tough out here, man. 2 ABA standards. Okay, they cite that here. We'll keep it moving. Thus, the granting of a reasonable pretrial bond must be preserved. Otherwise, the presumption of innocence secured only after centuries of struggle would lose its meaning. In order to protect our firm foundational belief that the accused is presumed to be innocent prior to finding of guilt beyond a reasonable doubt. The prosecution alone has the burden of persuasion in convincing this honorable court that there are no set of conditions or circumstances that can be ordered to permit Young Thug pretrial release on bond. All right, and they're saying 2AB, 10.5, and 10DE, D and E. They say the state bears the burden of proving clear and convincing proof that pretrial detention is warranted. So, I mean, he's saying Young Thug shouldn't have been in jail this long, to summarize. This requires the prosecution to carry the burden of proving by preponderance, we got that one, of the evidence that this honorable court must deny Young Thug's motion for bail outright rather than set bond with conditions of the same in order to ensure Young Thug's presence in the court and protect the community. And Brian Steele saying they haven't shown that. It is so significant to deny Young Thug's pre-verdict bond that the Honorable Supreme Court of Georgia requires the Honorable Court to specifically explain why no bond could be set so our higher courts can evaluate whether there was a flagrant abuse of discretion when reaching that decision. No bond in a RICO case. I'm not sure what the numbers are on that, but I can't imagine it would be pretty common, especially when there's these type of crimes included in it. But hey, again, I'm just a layman. Y'all have to let me know in the comments if that's the case. When considering the pre-verdict bond, alleged guilt is extraneous, is completely irrelevant and not considered for pre-verdict bond analysis, as supposed guilt has no place in bail proceedings since Young Thug is presumed innocent. Yeah, there's a couple of factors that you have to take into consideration when determining whether someone could get bond or not. But as Brian Steele is saying here, or Young Thug is saying here, it can't be because you think the person's guilty. Our highest court explained that in a bond hearing, Young Thug bears the initial burden of producing evidence that he would not pose a significant risk to flee the jurisdiction and would return to court when required. Do y'all think that Young Thug would run? I'm not seeing it. Y'all have to let me know what you think in the comments. I don't see Young Thug being a flight risk. He doesn't seem like one that's going to back down, especially with this being his city, with this being done to him in his city, and everything that's going on in the case. I just don't see it. Not to. So here's the other thing that he would have to show: not be a significant threat or danger to the community or any person or property in the community, not to be a significant risk in the and to commit a felony while on bond, and not to be a significant risk to immediate witnesses or otherwise obstruct administration of justice. Well, so this one's interesting because we know our guy Lil Woody was up there singing. And we know even from this testimony that we've seen from him that he said he was a little nervous about his relationship with Young Thug. So as the prosecution, you may have something here. But going back to what Bruce Harvey said, with everything that's went on here, we don't know what Lil Woody would have said. So this is an interesting point here. I would be interested to see how the prosecution would respond to that. Let's keep it moving. So Brian Steele, now he's going to defend and he's going to show the reasons why Young Thug should have been given bond. Mr. Williams, aka Young Thug, is not a flight risk. I agree. To meet this burden, Young Thug must first present evidence showing his roots in the community, which would include the length and character of residents in the community, which is what I just mentioned. Like this is his life. He lives here. Everything he has is here. Employment status and past history of responding to the legal process. Young Thug was born and raised in Jonesboro, south of Atlanta, Georgia. Since birth in August 1991, Young Thug has maintained his residence in Atlanta, Georgia. Although Young Thug has traveled the globe, he's He's an artist, has performed his music and artistry in every continent, save Antarctica. Thank you for putting that note in there, Brian. Oh, this guy. You gotta love him. He always returns to his homes in the Atlanta, Georgia area. In fact, days before the return of the original indictment and the arrest of Young Thug returned to Atlanta, Georgia from the country of Norway. Young Thug is one of 11 children, and he is the father of 6 children. Oh my gosh. Ages 16, 13, 12, 11, and 9. Okay, we're not going to say they're twins because, you know, there could be another explanation for that. I'm going to leave Thug alone. All of Young Thug's family lives in Atlanta, Georgia area, including his parents. There is not many among us who has a stronger roots in the community than Young Thug. And he has, I mean, you've got the whole YSL record label that surprisingly wasn't mentioned here, based in Atlanta. You have tons of artists that work, record, release music under YSL. So, I mean, that's another point. Young Thug has been working since he was 6 years of age. At age 14, he was recognized and began performing his music for audiences. As a teenager, he had a manager, and within a few years, Young Thug was signed by Atlantic Records and was paid $1 million. Young Thug is currently gainfully employed, tirelessly works at his artistry and other lawful business ventures that include clothing lines, modeling, owner of a successful record label, and various investments. Young Thug has demonstrated a strong history of lawful employment. Young Thug has appeared in court in the past, represented by undersigned counsel Brian Steele, for approximately a decade, to wit, Young Thug's entire adult life. Wow. Yeah, so Brian Steele's a day one, and you can tell from the way he's been defending. I don't even want to minimize it to him saying his client, because I'm sure they have a pretty great relationship behind the scenes, but yeah, that makes a lot of sense. Young Thug has never missed nor has been late for a court appearance. Young Thug has a history of responding to the legal process. Undersigned counsel is in possession of Young Thug's passport and has permission to surrender this passport as directed by this honorable court for purposes of bond. So they're saying he's not even trying to flee the country. It's just been 19 months. He wants to get up out of there. Furthermore, when a bonding company writes a bond for this criminally accused, the company takes financial risk in ensuring the criminal's accused presence in court. In the case at bar, Free at Last Bonding Company has agreed to write a bond set by this honorable court, and the representatives of Free at Last Bonding Company are motivated to keep track of Young Thug and prevent any possible flight. Okay, see easy out bonding versus state. Got it. Young Thug intends to present witness to testify at the renewed bond hearing. Specifically, Young Thug's parents, managers, members of his record label, child's friends, business associates, and the like will be present in court to testify and show the support for the granting of pre-verdict bond for Young Thug. Also, just a side note, Young Thug respectfully requests a date certain to argue this renewed motion for bond so that out-of-state witnesses can be present to testify before this honorable court. And, you know, I talked about the court of public opinion. Excuse me. This, in my opinion, is something that we need to address and I think needs to be reminded. I know a lot of us will say we would never be in this situation. So let me just say, put yourself in a situation to where you, by your own actions or not by your own actions, you are having to deal with the court system. You're going to want to be seen as innocent before until proven guilty, right? And a lot of people in the court of public opinion aren't giving Young Thug that right, which it is his right. So you have to look at it from a legal standpoint and from the standpoint of they still have to prove that this man did what he did, even though some may think he did, some may think he hasn't done what he's done, what they're saying he did. But to say he doesn't deserve bond or he shouldn't be out on bond just goes against everything that I think each one of us would want and how we would want to be treated as well. So anyway, I'm done preaching. Young Thug is not a significant threat to the community or any person or property in the community. Young Thug has taken the initiative to secure the commitment of full-time off-duty sworn law enforcement officers to watch his home and secure his home 24/7. Wow. If house arrest is ordered by the honorable court as a condition for pre-verdict bond. So if he has to be house arrest, he said, okay, that's fine. Y'all put me on house arrest, do whatever you need to do, and we can have police officers there all day. Mr. Williams will submit to the condition that any person who would visit at his abode would have to be on an approved list provided to the honorable court as well as the district attorney's office. And if the individual's name is not on this list, that person will be denied entry to his home. I don't see how he didn't get bond. Like, what else? Why do they need to keep him in jail? Sad, man. Moreover, any visitor will have to consent to being searched physically and electronically by the off-duty sworn police officer. And if the visitor does not agree to consent to search, the person will be prohibited from visiting Young Thug. Young Thug also agrees that any of his text messages, phone calls, emails, and other forms of communication in any matter can be secured and the information provided to this honorable court. Why is he in jail? What is going on? This is another bad look for Fulton County. Why is this man in jail? He said, hey, y'all, I will have a webcam in my house. Y'all can see everything that's going on and we can live stream it on YouTube. Can I just not be in jail, please? And somehow they said, nope. Gotta sit in jail. Sorry, Mr. Williams. Crazy, man. Let's go back. Young Thug also agrees that any of the text messages, phone calls, emails, or other forms of communication in any matter can be secured and the information provided to this honorable court if desired if Young Thug was in custody and on a recorded line. It seems pretty straightforward to me. The cost of the 24/7 off-duty sworn police officer detail, as well as the cost of the ankle monitor, he said he'll take an ankle monitor too, good Lord, would be incurred by Mr. Williams. So he's going to pay for all of this. With these parameters in mind, it cannot be said that Young Thug would be a threat or a danger to the community or any person or property in the community. Undersigned counsel will agree to meet with Young Thug at his home to continue to prepare for trial. Seems pretty straightforward. I don't know. The above conditions place Young Thug in custody in his home. Specifically, our General Assembly has provided for the creation of electronic pre-verdict release to assist the sheriffs in alleviating jail overcrowding by creating alternative methods of pretrial release, monitoring, and home confinement. Let me tell y'all this, man. As a music fan, let's go to the music side. Young Thug gets out on bond and drops an album or a song. It's over. It is absolutely over. That would go crazy. I would, man, if he gets out and makes some new music, y'all know I'm a fan of Young Thug's music. That would be absolutely insane. We would forget about Kendrick Lamar. We forget about Drake. We forget all about Eminem and anybody else who's dropping music right now. The music industry would be in shambles. Young Thug would break records like you had never seen. Hey, that's what I want to see, honestly. The legislature found that electronic release, monitoring, and home confinement incorporates modern technology to accomplish various purposes. Therefore, our General Assembly explicitly recognizes that Young Thug's home is a place where he can be confined and restricted in movement for the purpose of electronic pre-verdict release on bond. And see Brown versus State. Ordering Mr. Williams to wear an ankle monitor and to be in total lockdown in his home is the equivalent to custody and confinement, and has been deemed lawful confinement without the punishment imposed by the current county jail conditions wrongly imposed on Young Thug. I agree. Young Thug endures the torturous conditions in the county jail, to wit, 22 of 24 hours a day locked into a small cement cell with no contact with any other human except when his counsel visits and in court proceedings. That is terrible, man. Inedible food, living in squalor, ant-infested rooms, and unable to see any activity / movement out of the cell's windows. That's terrible. And if y'all have heard some of the stories about the Fulton County Jail and some of the things that go on in Fulton County, there's people that have, well, I'm gonna leave that one alone, but y'all could do your research. Young Thug is not a significant risk to commit a felony while out on bond. Young Thug is not a convicted felon. A lot of people didn't know that, nor do they care. They just know his name's Young Thug. But I mean, he's truly humble under God, okay? That's what it stands for. So, Young Thug, y'all, give him a break. He is not a convicted felon. This fact alone satisfies this bond factor. Moreover, law enforcement officers executed a search warrant on or about Monday, May 9, 2022, after the arrest of Young Thug on the original grand jury indictment, and indictment to search drugs and guns were allegedly located in his home. At the time of this search, there were numerous people at / in Young Thug's home. This is because others live at the home more often than Young Thug, who is at home intermediately, as Young Thug has several homes in the Atlanta area. Thus, Young Thug is not a significant risk to commit a felony while out on bond, especially with the use of the security and other conditions offered above. So I wonder if they're just saying that they still have to prove that this was all Young Thug's stuff, that those were his drugs and his guns. Does that make sense? Especially the use of security and other conditions offered above. Okay. Young Thug is not a significant risk to commit a crime. He is also not a significant threat to the community, property, or person in same. All right, see Williams v. State. Next, Young Thug is not a significant risk to immediate witness or otherwise obstruct the administration of justice. Now, again, I don't think Thug should be in there, but if we're going to be fair, and we're going to look at it from both sides, this might be where I disagree and where I could see he might not be able to get this bond. And we'll listen to what he says, but just seeing this note, that's my opinion on that. We'll see. Young Thug has suggested a condition of bond that all of his calls, text messages, and other means of communication are not monitored, save privileged communications. And additionally, he will be secured in his home when not present in court. This will prevent any possibility to intimidate. Oh, I read that wrong earlier. I apologize, y'all. To intimidate a witness or otherwise obstruct the administration of justice via electronic means. In today's times, the legislature has provided that ankle monitors are a humane method of incarcerating a criminally accused without the need for punishment that is endured by languishing in the county jail, punishing someone who is innocent because they haven't been proven guilty. The honorable court's foremost consideration with fixing the amount of bail should be the probability that Young Thug, if granted bond, will appear at trial. Young Thug is a respected high-profile artist who has positively impacted lives of others who would otherwise never break the poverty line. And it's interesting because you see, was it the Danza Project interview that Lil Woody did? He actually mentioned that He mentioned how Thug helped him see how life could be better, how Thug helped him see that he didn't have to be in the streets and he could be successful, and that there was another part of life besides running the streets or doing whatever he does. So this is a great point by him. He is highly respected, high profile artist who has positively impacted lives of others who would otherwise never break the poverty line. This is true. Young Thug has made tremendous positive impact in our community. Young Thug is a positive member of society. He will continue to lawfully and ethically fight these baseless charges governed by the above facts and law. Young Thug satisfies all four prongs of A versus state. Young Thug satisfies these four bond factors, and thus the burden of production falls onto the prosecution, and the prosecution always retains the burden of persuasion that there are no conditions of bond that can be crafted to permit Young Thug to be entitled to pre-verdict release. Okay, so Brian Steele didn't spend too much time on this section, and as I mentioned to y'all, I think I know why, but he makes a good point. If I'm the prosecution, I'm gonna spend most of my time on point 4. Let me see here. See, Dunn versus Edwards. In our society, liberty is the norm. Custodial detention prior to verdict is carefully limited to few people. Indeed, the most important element of liberty is to be free from physical detention by one's own government. Based upon the above, Mr. Williams, aka Young Thug, must be granted a reasonable bond with the conditions of the same. Wherefore, Young Thug respectfully requests a reasonable bond be set by this honorable court with reasonable conditions of the same. Respectfully submitted by the Attorney of the Year, Brian Steele. All right, this is a simple question I have for y'all in the chat and in the comments. Is Young Thug gonna get bond? Let me know what you think. What are y'all saying in the comments and in the chat? Let me see. And I know we got some people that ran out of gas over here. I appreciate y'all speed here. We still got over 200,000 people in the building. Thank y'all. What does El Papicito say? Based on my training and experience in law enforcement profession, there is a probability that Thug and his entourage are guilty of some, if not all, of these crimes, proving it is questionable. Yeah, and that's where I'm with you, El Papicito. I think you're 1000% right. Again, section 4, this is the one that gets him, I think. This is going to be hard. This is going to be a tough one to beat, but we'll see what the state says. Call for backup is up in here. That's a dope name. Shout out to you. It says no witness has said they were scared at all. The prosecution has implied it, but never proved it. Let me see. I'm trying to think when it was said. Lil Woody said he was worried. Lil Woody said he was worried about Young Thug because he heard rumors that there might have been a hit out on his life from Young Thug. And then allegedly Lil Woody came to Young Thug and said, hey, what's up with this, man? Why are these rumors circulating that you're trying to, hit the delete button? Young Thug said, no, man, it's cool. We're all good. So the man who is on the stand right now, he was the main one that said, and he can't take it back. At one point, I was fearing for my life. So that's going to be a tough one. What does Amy say? She says, wealthy wisdom. That's what I've been saying. I said to somebody, look the other way. I think Biden stepped down because all their plan didn't work out. Trump shouldn't be here. Oh yeah. Y'all are talking about our guy Trump over there. Yeah. I'm surprised Trump wasn't in the chat. We have Trump in here usually. Let me read a couple more comments and then we'll get into the last one. We've got, well, no, it's not the last one. We got a couple more. So we've got this response. This response from the state that we're going to go through. And then we have one last motion as well. And this is the one I think we're going to skip ahead a little bit. I think couple responses from the state are cool. They're not going to take as much time. So I'll save those until the end. And we're already at 2 o'clock. Y'all know I was supposed to be out of here 30 minutes ago. I'll be talking too much. I can't help it. Roro says he will get bond, but Love is going to object and go stand in front of his cell door. Oh, man. Yeah, I do need some more water. Thank you. I do need some more. Shout out to, is it Kim Colors? Okay, Kim Colors is in here. Appreciate you stopping by. I got another poll I want to ask y'all in the chat. But what did y'all say about that last question I had in there, which was, will the YSL RICO case be a mistrial? 84% of y'all said yes. I know, Amy, I got it. Okay, so I got another one for you. Shout out to Mackie Slim, said Trump 2024. What do y'all think about that? Y'all think our guy Trump has got it in the bag, or Kamala is going to put up a good fight? You have to let me know that too. Okay, so here's the question. Will Young Thug get bond? It's a simple yes or no question. And then if y'all want to in the comments, if you want to get a little bit more detail, you can. So let me, you know what? I definitely need to grab some more water. So y'all give me 1 second. I got to get a refill. I'm going to play some music for you and we'll be right back.
You never listen to what no haters say. We pray for them, but we gon' move it this way. We moving forward, y'all.
We can do anything. We can't be worried about what they say. My brother, my sister, just believe in yourself. Believe in your skin. Believe in your health. Believe in yourself. Believe in your talk. Believe in your walk. Believe in yourself. Believe in your skin. Believe in your health. Believe in yourself. Believe in your talk. Believe in your walk. Believe in yourself.
I feel like George Floyd, yo, I can't breathe. It's hard to conceive on why they wanna kill we. I think they wanna break our spirit. The youth won't hear it. We die over loose. These cops scared to quit it. I send my love to Eric Gardner's family, cause them pigs went and took away somebody's daddy. Sandra Bland, Trayvon Martin, Ahmaud Arbery. The world sees what's happening. Yeah, so in the midst of our hardest pain, we believe in ourselves and face our darkest days. You know, they be mad when we come together. So after the protest, stick together. Take the pledge. I will fight but won't kill a brother.
All right, y'all, we're back. Shout out to the Bishop, man. If y'all want to know who sings these songs that you hear at the beginning of the show, go check out my guy, the Bishop, over on Spotify. This song's called Believe in Yourself, and we usually play it on the outro. Also, the Good Morning song is by him. Go show him some love, man. We always supporting the artists in the building. Shout out to the Bishop. All right, let's go ahead and get into this next motion. This one's gonna be a good one because it applies to me, which is crazy. But this is gonna be a fun one because y'all know I love saying I told you so. I love saying I told you so. And in this situation specifically, this is definitely one of those I told you so moments. Now, y'all have made one of my more popular videos is a video where I talked about Kayla and Lil Woody and some of the things we're seeing with their YouTube videos being taken down and how they were laughing about the state watching their YouTube videos. Well, what I said was right. They're watching. They are watching everything that's going on. They see everything that's being said. And the state is now saying that they have a big issue with all of these YouTubers out here talking to people who are sworn witnesses who are attorneys in the case, attorneys themselves, some of them starting YouTube channels, going over to other YouTube channels and talking about this active case. And the state is trying to put a stop to it. Let's go ahead and get into it. This is going to be an interesting one, to say the least. Check out what they're saying. State of Georgia versus Young Thug. And this is a letter to Judge Whitaker. State's motion to restrict extrajudicial statements. What does that even mean? We're going to get into it. Comes now, the state of Georgia, and moves this honorable court to instruct the defense to refrain from further extrajudicial statements about this case moving forward. Now, the prosecution, they're probably not happy that they're being seen in a certain light. No one's invited them to their YouTube channel. It's tough out here. It's tough out here. But they're saying, no, I don't get a YouTube channel. They don't get a YouTube channel either. Well, let's keep it moving. Georgia Rule of Professional Conduct, Rule 3.6 prohibits lawyers from participating in litigation from making extrajudicial statements a reasonable person would believe to be disseminated by means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing and oh man, they're killing me. So basically, they don't want these lawyers talking on YouTube, and they don't want them doing interviews because it's going to paint things in a certain light. They got these words back to back. I'm struggling over here. A relevant factor in determining prejudice is the nature of the proceeding involved, with criminal jury trials being the most sensitive to extrajudicial speech. The character, credibility, reputation of a party, and any opinion as to the guilt or innocence of a defendant are subjects deemed to be more likely to have a material prejudicial effect on a criminal proceeding. Have we seen any of this lately? Can y'all think of an instance where this may be certain things that they're talking about? Again, I'm not a beat a dead horse, but I was right. All right. Defense counsel has made numerous extrajudicial statements explicitly about this case while a jury is sworn and seated during the state's case in chief. Defendants Young Thug counsel Brian Steele and Keith Adams. Brian Steele spoke about this? I must have missed that. Where did... Yeah, we'll have to see if we can find that. And they have a note here. And Keith Adams. Okay, I saw Keith Adams. He was on... What's it? Infamous Sylvia's channel, I believe. Defendants Yet Gotti attorney Doug Weinstein has been all over YouTube. He's going crazy, man. Doing Twitter spaces, X spaces, and all that. And defendant Stillwell's SB's attorney Max Sharp. He also, I believe, did an interview with infamous Sylvia. Have all made extrajudicial statements up to the media explicitly discussing this case in violation of Rule 36.6. Now, because I'm not a lawyer, I wasn't able to point to a specific place where this would be an issue. But I told you guys, just looking at this from a professional standpoint, why would these people be talking about this ongoing case, this ongoing trial on YouTube, talking about it in Twitter spaces? I said, to me, it doesn't make sense. I don't want my attorney that's representing me to be on YouTube. And I definitely don't want my attorney asking me to come up to their YouTube channel and talk about the case. Is it just me? Maybe I'm wrong. Again, y'all are going to call me haters because I was saying all this stuff about what was going on with Kayla and even some of the things I said about Doug Weinstein out here. I just personally didn't get it, but they're saying it's fine. The extrajudicial statements have included, among other things, interviews and statements to the Associated Press, 4 of those interviews have been 25, 33, 43, and 107 minutes in length. The statements include, among other things, the attorney's view and opinions about the case itself. This is exactly what I said. Y'all got this from me. Shout out to 88 Love. I appreciate you for watching the channel. Thank you so much for the support. Hey, run the views up. Make sure you send out an email and let everybody know they need to watch the channel, because I didn't see anyone, honestly. So y'all have to tell me in the comments in the chat. I didn't see anybody calling this out. The reason that video I did on Kayla, I think, went so far because I was the only one saying, you guys, I don't understand why y'all are on YouTube talking about this. And now we actually have a rule that says they're not supposed to be talking about this. Now, is it going to be a big deal? No, it's not going to be a big deal. But my hunch, as I was saying in the comments, is common sense just says this shouldn't be allowed. It doesn't make sense. Let's keep it moving. I got to get my I told you shows out there. The statement includes, among other things, attorneys' views and opinions about the case itself, opposing counsel. Ooh, their feelings are hurt. I told y'all. Some feelings got hurt here. The now former judge, the jury, the outcome, and the guilt of innocence of specific defendants. Pursuant 1513, courts have the power to control in the furtherance of justice the conduct of its officers and all the persons connected with a judicial proceeding before it in the matter appertaining thereto. Wow. The state thus moves this honorable court to instruct the defense to refrain from making extrajudicial statements about this case moving forward. Now, I mentioned earlier, the lead attorney covered this and he made an excellent point. And I can't remember if it was lead attorney or AV. I think it might have been AV. They made a point about the defense or about the prosecution, AKA the state. Y'all may or may not remember if you were following the Trump trial that was going on here in Georgia, specifically in Fulton County. And then Fani Willis and Nathan Wade, they were on the stand. They were having to defend the fact that they were spending all this money and they were having an inappropriate relationship behind the scenes. And during that time, Fani Willis herself, the current district attorney, went to a church, was doing interviews and talking about how she's being discriminated against, what was going on with the case, how we got to bring this man down. So it is a little bit hypocritical here. And shout out to Lee for pointing that out. So I don't know, again, if this is a big deal, but we can now see that Rule 3.6 says that this is something that's not supposed to happen. Will that be something that the defense points to in their response? Especially since Fanny's involved in this, I could see that being the case. And if they did, they either heard it here or they heard it from the lead attorney. All right, y'all give us our credit. Dang. Now, these exhibits are going to be fun because here is where they show everything that's been said, all the interviews that have been done so far, and the reason that they should be removed. All right, Exhibit A, below, please find Brian Steele's statement regarding the recusal order. Young Thug is innocent of the charges brought in this indictment, and to clear his name, he sought a speedy trial, one in which he would receive constitutional guarantees of a fair trial with an impartial judge presiding and ethical prosecutors following the law. Sadly, Judge Glanville and the prosecutors have run afoul of their duties under the law. Young Thug is grateful that the reviewing court agreed to him and entered the order recusing and disqualifying Judge Glanville from presiding over Young Thug's case. We look forward to the proceeding with a trial judge who will fairly and faithfully follow the law. I don't have a problem with Exhibit A. Exhibit B, here's where it gets fun, y'all. Check this one out. Exclusive. Young Thug's attorney speaks out on Glanville recusal. Keith Adams, where are we going? They have the video and they said the complete interview is 15 minutes. Oh, okay. The complete interview takes place between the 15:12 mark and the 55:15 mark. Again, the state is watching because we asked for them after we saw previous motions where they cited these videos that they would put timestamps. So they finally put solid timestamps in here. And then they're saying 23 through 9, 23, 9, and 23:16 is where they have an issue. 23:36 and 23:43. Okay, let's check it out. Let's see. We'll go to 23 minutes and 9 seconds.
With their other cases, much like by way of
oh dang! I hope they don't. Man, I might get called as a witness, y'all, because I definitely covered this. Dang, they might have got me. So this is the problem this is the issue that they have. Check this out.
To be unbiased, and then let's try it and let the chips fall where they may. We don't need prosecutors doing unethical things and trying to trick the court or be dishonest to the court.
Uh-oh. Yeah, that's no good. He said, you don't want prosecutors doing unethical things or trying to trick the court. Can't do that. Let's go to 23:36, which is the next one. Or is it 23:36? Hold on a second, y'all. 23:36 through 43.
We don't need that. We've certainly conducted ourselves in an ethical manner throughout the course of this trial. And that's all we want. We want everything to be fair. And we firmly believe that if everything is done the way it's supposed to be done, if it's a fair, unbiased, impartial trial, that, Jeffrey Williams is going to walk out of that courtroom a free man. He's going to be exonerated of all of these things that he's been wrongly accused of.
Yeah.
Wow. Okay. So again, making some pretty bold statements there. And shout out and congratulations to Infamous Sylvia for being on the records officially. I don't know if that's a good thing or a bad thing, but congratulations. Exhibit C. Okay, this is a quote from Mr. Weinstein. It says the Associated Press reached out to Glanville and to a lawyer for Young Thug seeking comment on Monday's ruling. A spokesperson for Willis's office declined to comment. What do they say? While I respect Chief Judge Glanville and his service to the community and country, he simply became biased over the course of this case. Kendrick's lawyer, Doug Weinstein, said in an email. He added that he looks forward to trying the case before an unbiased judge, but said the only outcome at this point is a mistrial and bond for Kendrick, who has been jailed more than 2 years. Yeah, it sounds like the prosecution, they're trying to get their get back. Brian Steele, he got his judge in there, Judge Whitaker. All right, he got their guy, Judge Glanville, out of here, and now there's some retaliation taking place because they didn't like what happened. Here's another one. All right, Judge Glanville recused. Attorney Doug Weinstein discusses live with journalist Megan Cuniff. I think I'm saying it right now. Megan Cuniff. Here we go. Judge Glanville recused. So they're saying we need to go to 15:11 and see what they're talking about. All right, let's see.
What's up, everybody? We're going to go live on TikTok too.
And shout out to Megan. I've been following her on X.
What's up? What's up? What's up?
Let's see what Mr. Weinstein's saying.
Trial. Unfortunately, in a way, because again, I think we're winning. I don't think, as you said, I don't think any jury right now, even without us presenting any case at all, a jury could find RICO violations. A jury could find murder. Now they're in the middle of their murder case, but I don't think it gets any better for them.
Yeah, no, and it's confusing. I mean, it's kind of just hard to follow. Like, what is their theory?
So there's a part of me for sure that says, I don't know if I want to restart this case from scratch.
Yeah, they're up there singing, man, and the prosecution does not like it. Let's go to, what did they say? 1910 through 1913.
By the court.
Oh, please don't make me crawl into their headspace.
Yeah. All right, here we go. Let's rewind and see what the question.
Of them just dropping this on their own without being forced to by the court.
Oh, please don't make me crawl into their headspace.
Yeah.
I don't know. I mean, that's their call. I mean, I don't think their case is very good. Do they want to retry this? Do they want to indict it in a different way?
Dang. He said, I don't think their case is very good. We got a couple of more here. This is Exhibit E, Young Thug / YSL trial update. Megan interviews defense attorney Max Shart. Okay, so this is Megan's interview, and it takes place from 52:35 to 52:40. So it's just 5 seconds that they're referencing here. So let's go 52.
All right, we need to get the curtain raiser for my intro here. Welcome to the live, everyone.
Where is it?
Glad to see everybody tuned in. We've of course got some big news to discuss today with the.
There we go.
In this, I mean,
and this is SB's attorney.
So far in the trial, there's if the
Shannon
trial
Stillwell
continues, there'll be parts of the trial that do not directly or even indirectly involve my client Shannon, other than he's charged with RICO. But so far in the trial, most of the witnesses have involved Shannon to a large degree. And the reality is Shannon, you know, I'll say it today, I'll say it tomorrow. He is innocent of the charges in this indictment. But the reality is, if you read the indictment, Shannon has more charges than anyone. Okay.
All right. So again, I am team shut up and do your job. All right. Just y'all don't need to be out here on YouTube doing interviews. You can have plenty of time to do that once the trial is done. But I told you guys multiple times in the videos I made in the past that I think this is a bad look. It seems unprofessional, and it doesn't make sense to me that they would do this unless they are intentionally trying to prejudice. They're trying to make things look and seem a certain way. And this just isn't a great look. And I think they're doing a disservice to their clients. So I gotta, as much as I hate it, I gotta go with the prosecution on this one, because this is something I've been saying over and over and over and over. I was called a hater because I called people out and said, I don't get why y'all are doing this. It's not worth it to me. And then we've got another video here. We've got Mr. Weinstein talking again. As I mentioned, he's done a lot of videos, and that's pretty much the end of it. Let's find one of these, and then I'll get off of my I told you so tour. Let's go 1550 on this one.
Oh, by the way, I have to do a quick aside just to tell you, okay, I don't want to forget this.
Yeah.
I think that your TikToks and your streams and you're explaining the law and cases to lay people, you do an excellent
making a video. I try to make sure that the humanity in it is there and remains, and I try to be respectful of that. And so from your perspective, how does all of this, how do you take all of this? Is it good, bad? Do you want us to stop? Do you want us to keep going? What is that?
Yeah, I'm just speaking personally, and at this point, I'm not even speaking for the other attorneys who work with me representing Mr.
Sure.
Kendrick, but I'm all in favor of it. I mean, Diamante Kendrick has a constitutional right to a public trial.
Mm-hmm.
You've seen, if you've watched it, you've seen me fuss whenever the judge has tried to shut down having witnesses broadcast by video.
Yeah.
I believe that that's part of his constitutional right to a public trial.
Yeah.
He's accused of serious crimes that he did not commit.
Mm-hmm.
So to the extent that the public can watch what's going on and learn and see the case that the state thinks that they have against him. And of course, it's ultimately it's up to a jury to decide. But I'm more than happy to have the public watching this come to their own conclusions and see that Mr. Kendrick is not guilty of these crimes. So,
all right, y'all, there it is. Let me know what you think. I told you this was going to happen. So I don't know if anything happens because of this, if they're going to shut down a lot of these interviews, if there's going to be any issues with live streaming the case. God, I hope not, because that would be a shame. But I don't think they can stop at this point. Y'all let me know what you think in the chat. And everybody who said I was a hater, just remember 3.6. All right. Rule 3.6 said I was right. Let me know what y'all think in the comments. Wow. We had one more motion to get to, but oh man, it's so late. We had so much to get to today. Shout out to everybody who's in here. We had over We got over 400 people in here. 400. Wow. Thank y'all for the love, man. What are y'all saying in the chat? We got a bunch of people in here. We got Big Dookie Must See TV is in the building. Hey, yo. Shout out to you. Y'all are having a political conversation in the chat. What does Roro say? I say bond only because I'm going by first and foremost. The Constitution says innocent until. Also, what I have heard in the trial, he's not a CF and I don't know all the details. Okay. Y'all are talking about Kamala Harris. I ain't care about that. Shout out to Alexis is in here, said you are a hater because it's not against the law for lawyers to make statements. See, I'm a hater. Okay, well, all I did was say what Rule 33.6 says. I'm not a hater. I'm just pointing out the obvious. But shout out to Alexis. Shout out to the haters. Lauren Robinson says, come on, ClassE. She wants me to do that last one. 442 likes. Y'all are talking about the presidential stuff. I'm going to save that for later. We've got Sean in here. Sean Barron says they're not going to give him bond because it's too many people that took plea deals and got released back to the streets. Witnesses are free. And they're going to say it's a risk to give them bond. Great point. I brought up Lil Woody, but yeah, that's true. Wealthy Wisdom says no, Rule 3.6 don't cover everything. Mr. Tesla says, you hate ClassE. Yeah, ClassE, we hate you because you're right. I know, right? I'm going to look up, I guess I should look up Rule 3.6 before I start gloating, right? But either way, even if it doesn't cover everything, they still have a case. Let's see. American Bar Association. Oh, yeah, this is short, sweet, and to the point. Rule 3.6, trial publicity. A lawyer who is I got to zoom in on this. A lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extra judicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing, I think it's prejudicing, and I always mess this up, proceeding in the matter. Notwithstanding paragraph, a lawyer may state the claim, offense, or defense involved and accept, when prohibited by law, the identity of the persons involved, information contained in public record, that an investigation of a matter is in progress. Yeah, saying that the prosecution was doing things dirty by someone who's involved is just not okay. And you can see that here. Scheduling result, a request for assistance, a warning of danger concerning the behavior of a person involved, a criminal in the case. So, yeah, I don't know. To me, I would just avoid it. It's just better to avoid it and not even take that risk. But maybe that's just me. Smoking the ones in the building. What's up, Mike? Wealthy Wisdom says Rule 3.6 covers anything to prejudice the case. If the lawyers speak out about the case, don't say anything to prejudice the case, it's fine. The jurors shouldn't be watching anything anyways. Let's see. Sean Barron says, I hate Young Thug got caught up in this stuff, but his lawyers know this stuff will get denied by the lawyer. The lawyers are just soaking up his money. Brian Steele, I mean, yeah, they're getting paid, but Brian Steele's been with Thug, as we saw, for over a decade. So Young Thug's entire adult life. So they have a connection. Alexis says, I agree that it's not a good look. It's just not illegal. Weinstein is going live with Kunif today. I saw that. Yeah, somebody said that earlier. Appreciate you stopping by, Alexis. Yeah, and that's all I was saying. And just out of safety for everything you've built as an attorney, to me, it seems awfully risky. And what do they benefit? I don't know. Maybe Doug Weinstein is gonna start a YouTube channel at some point. You know, maybe Max Sharp will, maybe Mr. Adams will. Why speak out about it? I think is my thing. Lauren Robinson said Brian Steele is basically family. Yeah. What did y'all say when it comes to Young Thug getting bond? Let me see. Wow, I'm surprised at this response. 71% of you said yes. 28% of you said no. Interesting. All right, so we've got the state's response, and I think that's really what people want to hear. So maybe I'll just go through these really quick because they're very short. Man, I want to read through these so bad. But I really got to get out of here. All right, should we do it, y'all? Should we go through these response from the state real quick? Let me know. What do y'all think? And shout out again to all 400 of y'all in the building. I appreciate it. Should we do it? Brian Steele is a great lawyer, but this ain't looking good. Too many witnesses and fake friends who turned on him. Yeah. Okay, Alexis said, let's get it real quick. Mr. Tesla says go. Here we go, y'all. We're going to do it. We're going to go through it real quick. So the state has finally responded to all of these motions that have been brought forward in the last 24 hours. It's going absolutely crazy. And the state is not holding back in their responses. We're going to go through these and read these real quick. Y'all let me know what you think in the comments. If this was a good response by them, the first thing we're going to go over is a notice from the state. All right. We've got the state of Georgia versus Young Thug. It's a letter to Judge Whitaker. Notice, the state hereby notices the defendants in this case and this honorable court of the following. It has come to the state's attention that on May 2nd, 2015, the honorable court issued an order of recusal with regards to a motion for a new trial. All right. The fact underlying, the prior case are related to the present case and are not a part of this case. The prior case involved the December 22nd, 2007 murder of James Yarborough. The present case involves allegations of criminal activity by and through members of YSL, which formed years later in 2012. On information believed, the recusal order was based upon the court's prior supervisory role over the appellate unit of the district attorney's office during the presidency of Greer's motion for a new trial. That order might even have been issued in error, as the amended motion for a new trial Mr. Steele filed on Greer's behalf on December 2016 before the order of recusal already listed the same judicial officer who ultimately resolved Greer's motion for a new trial in 2019. Now, what in the world are they saying? We're going to get into it here in a second. Although Greer was a confidant in the present case, Greer pleaded guilty in the present case in November 23. The state provides this notice simply as a point of information. Now, y'all are probably wondering, who in the world is this Greer dude? Well, this is someone who is related to Young Thug. He goes by the rapper name Unfunk, all right? And he was represented by Brian Steele. Now, with the state pointing this out, they're trying to show that, hey, there might be something there. There might be some type of conflict, and you guys need to keep that in mind as we go throughout the trial. And I highly doubt that this is the last time we're going to hear about Quintavious Greer or the fact that Brian Steele represented him. So now we go back to the state's response to everything that went down today, right? And that went down yesterday. And they filed this at 11:21 p.m. They filed this at night. Check this out. State's response in opposition to defendants Williams' motion to challenge factual findings. Following the recusal of Chief Judge Glanville, precipitated by the motions of defendants Young Thug and Yak Gotti. Defendants Young Thug has filed a motion to challenge the factual findings made by Judge Krause in her order recusing Judge Glanville. All right, for the reasons cited below, the state respectfully moves this court to deny the relief of Young Thug's motion request. In support of this motion, the state shows the honorable court as follows. Now, if y'all are wondering about the motion to challenge factual findings, we talked about it in another video and we went through it. And Brian Steele was basically saying that, hey, Judge Krause, when she ruled, although she said she was throwing Judge Glanville out, she also said that he didn't do anything wrong. And Brian Steele said, and I completely and 100% disagree. And again, this is from Thugger Daily. And we went over that in another video. Y'all can go back and check that out. But what the state is saying here is that Brian Steele was wrong and there's an issue. Let's get some background. Yak Gotti and Young Thug each filed motions to recuse Chief Judge Glanville from this case. In support of their motions, each defendant submitted an affidavit or affidavits. The recusal motion was assigned to Judge Rachel Krause. On July 17, 2024, Judge Krause ruled on the motions and entered an order containing written findings of fact and conclusions, as required by Uniform Superior Court Rule 25.6. Legal authority and application of the law by Judge Krause. Basically, she did her job here. She considered the motions to recuse solely on the affidavit submitted by the defendants. And as required by law, Judge Krause included in her recusal order written findings of fact and conclusions as mandated by Rule 25.6. Even when the motion to recuse has no merit, if a judge is perceived as refuting a charge is refusing a charge of bias, the judge's actions create a basis for recusal. That's why I was messing this up. I kept seeing basis. My bad, y'all. Let me read this one more time. Even when a motion to recuse has no merit, if a judge is perceived as refuting a charge of bias, the judge's actions create a basis for recusal. Judge Krause wrote that, and we talked about this again, so we're not going to read through that, but basically transferring the case to another judge for consideration, Glanville necessarily determined that the recusal didn't need to happen. Judge Krause agreed generally with Judge Glanville's assessment of the propriety of the ex parte meetings, but found that Judge Glanville created a basis for his recusal when he added facts, provided context, questioned the veracity of allegations, and otherwise explained his decisions and actions, and argued why those actions were proper. Judge Krause found that in presenting his record as to recusal issues and ruling on Yak Gotti's motion, Judge Glanville evaluated and accepted the truth of his own factual allegations, mandating his recusal, which is why he's up out of there. First Young Thug objects to the order reference to his recusal motion inclusion of hyperbole. The reference to hyperbole is accurate. More importantly, excuse me. I had to take a second there. More importantly, the reference to hyperbole is not itself a factual finding and is not a material issue for litigation. Second, Young Thug asserts that Judge Krause finding that the hearing in chambers was not proper is wholly against the law. That assertion is clearly incorrect. The hearing in chambers was regarding a witness immunity and compelled testimony. Such a hearing without the defense present has been held to be proper by the Supreme Court of Georgia, which ruled the defense has no standing to be present at such hearings. Nah, we're not buying it.
Stop the cap.
They should have been there. Let's stop it. For the reasons stated above, the state moves this honorable court to deny defendant Young Thug's motion to challenge factual findings. Respectfully submitted, 23rd day, July 2024, Adrian Love. Sorry, I pressed the wrong sound effect. So y'all gotta let me know what you think about that one. This is very interesting that they're going back and forth and really fighting this issue. As I mentioned in the previous video, when we talked about Brian Steele's motion challenging the factual findings, I think this was a chess move by him. And this is another chess move by the prosecution because they can probably see, as we mentioned in the last video, where he's going with this. So y'all let me know what you think in the comments and in the chat. And I'm going to see what some of y'all are saying, man. Wealthy Wisdom said, Love is trying to get the judge to recuse herself, but she is not coming out right and saying it. She's trying to intimidate the judge. Sean Barron says, as long as Lil Woody is living in Atlanta, they're not going to give them bond. They're protecting Lil Woody at all costs. They're going to deny bond for being risky and harmless to us. That's exactly what I said, Sean. And I think that's where Brian Steele is going to have trouble and where the prosecution is going to have their biggest case, because Lil Woody's already stated that he was worried about and in fear for his life when Young Thug was free. So that's going to be a tough one. Wealthy Wisdom says, Classy Beats, but that person is in prison for violating his bond. He is in prison for 10 years. So how is that necessary? What Love is bringing up? He isn't a free man. She's bringing it up to basically show that Brian Steele, that there may be an issue with Brian Steele being on the case. So again, I don't know if this is a chess move by her, because she's just saying, hey, I just wanted to bring this to y'all's attention, and it's going to be brought up and used later, but we'll have to see. Mixed Chick Samantha said, sir, I need you to tell some people to put some respect on Amy Nang. Oh yeah, she's got it over here. You already know. Let's see here. So I think I got most of the comments. We got to get out of here, y'all. Yeah, and Alexis knows. She said that's his brother. Yeah, listen, I don't like, we'll just call him by his rapper name. Funk. We're going to get up out of here, y'all. Again, if you are an artist or you just enjoy music, make sure you tune into the show tonight, 8 p.m. Eastern Standard Time. We're going to be live right here on the ClassE Beats YouTube channel, giving away some cash, brand new Shure 55SH microphone. And we are going to kick off the show with crowning the winner from Monday's episode and a versus challenge featuring 4 artists who are going to complete for that last, or not the last spot, that next spot in the season 9 tournament. Thank y'all again. Make sure you like the video on your way out. We'll be back tomorrow with another episode of the Music Morning Show at 11:30 a.m. Eastern Standard Time. I appreciate y'all. Hope y'all have a great rest of your afternoon. I'll see you tonight. And you always remember, keep growing, keep pushing, keep it classy. We go. Peace.
We're real strong people. We can do anything. We can't be worried about what they say. My brother, my sister, just believe in yourself. Believe in your skin. Believe in your health. Believe in yourself. Believe in your talk. Believe in your walk. Believe in yourself. Believe in your skin. Believe in your health. Believe in yourself. Believe in your talk. Believe in your walk. Believe in yourself.
Since everything starts with self, let me hold this mirror up and take a look at myself. Before I judge you, I gotta check myself. And I come to find out that that's good for my health, right? Change your mind and watch the whole body follow. So you won't hear me talking about I'm hitting you with hollows. I can't do it, got plans for tomorrow. And I ain't trying to bring my seeds no type of sorrow. Wait, cause fake rappers do fake-ish. I mean, most of basic get replaced quick. I'll never sacrifice my soul. Truth is, so I might never get 1 million records sold. But that's cool, cause I'm good with the creator. He nurtured my thoughts, so I present you with verbal flavor. You never listen to what no haters say. We pray for them, but we gon' move it this way. We moving forward, y'all.